I'd like to call the joint committee on the Assembly and Senate Higher Education Committees to order and welcome all of you here. We have a number of things on the agenda today. And before we get to the first item, I'll just run through it. We're going to start with the taking testimony on Senate Bill 511, the NC-SARA legislation, and then we will follow that up with an informational hearing on the UW accountability measures. And we have also noticed in the executive session there have been requests from both houses, members from both houses, to given the significance of the NC-SARA issue, they've asked to consider delaying the executive session on that legislation, which we will accommodate. We will not hold an executive session on that today, and both committees will notice that within the next few days or shortly. We will, as scheduled, hold an executive session on the accountability measures. So with that, I'm going to turn it over to Chair Murphy so that we can begin testimony on Senate Bill 511 and Assembly Bill 632.
So we will get testimony from Senator Harsdorf and from Bethany Anderson.
Do we want to
From oh, we could do that. Should we see who's? I think we'll have the clerks call the roll.
We'll start with the Senate.
Senator Harsdorf.
Here.
Senator Noss. Senator Gudex.
Here.
Senator Hansen.
Here.
Senator Bewley.
Here.
Representative Murphy.
Here.
Representative Brooks.
Here.
Representative Broadcast.
Here.
Representative Quinn.
Here.
Representative Rodriguez.
Here.
Representative Petrick. Representative Ballweg. Representative Krug. Representative Tranel.
Here.
Representative Mako. Representative Walks.
Here.
Representative Rousseau.
Here.
Representative Billings.
Here.
Representative Hesselbein.
Here.
Representative Jorgensen.
Here.
So now we will have testimony from Senator Harsdorf and from Bethany Anderson from Representative Joan Ballweg's office.
Thank you
for being here, ladies.
Thank you, Mr. Chair and committee members, for allowing me to speak in support of Senate Bill 511 and Assembly Bill 632. We appreciate the opportunity to speak in support of this legislation. This legislation would create a distance learning authorization board that may, on behalf of the state, enter into a regional distance learning reciprocity agreement. The U.S. Department of Education has issued federal program integrity rules to require post-secondary institutions offering distance education to be authorized in each state where a student taking an online course resides. As interest and participation in online courses grows, requiring authorization from every home state of those students taking an online course will create higher costs and tremendous administrative burdens on our institutions. In response to the federal rules, the National Council of State Authorization Reciprocity Agreements, commonly referred to as NC-SARA, was created and developed based on input from stakeholders. The creation of NC-SARA was to establish a state-level reciprocity process to help reduce the administrative burden and costs on higher education institutions offering online courses while ensuring consumer protection for students. Administration of SARA is taking place through already existing regional higher education compacts. Wisconsin, as you may know, is one of 12 states belonging to the Midwestern Higher Education Compact here in the Midwest, often referred to as MEC. SB 511 and AB 632 provides the statutory authority for Wisconsin to apply to become a member state in NC-SARA through MEC and lays out provisions required for participation in the reciprocity agreement. Specifically, this legislation would establish the Distance Learning Authorization Board, some we're referring to as DLAB, which would serve as the portal entity required of member states. DLAB would be administratively attached to the Higher Education Aids Board and have representation from the University of Wisconsin System, the Wisconsin Association of Independent Colleges and Universities, the Wisconsin Technical College System, the Education Approval Board, and tribal colleges. Agencies represented on DLAB would be responsible for staffing the board. Additionally, this legislation would direct DLAB to list authorized institutions based in Wisconsin in the administrative register, which is currently done through an executive order of the governor. Participation in NC-SARA requires establishing a process for processing student complaints, providing greater consumer protection for students taking online courses. It is important to note that this legislation does not require participation by any post-secondary institution. We urge your support of this legislation to provide institutions for higher education the ability to work more effectively and efficiently, as well as save costs and protect students. Thank you for your consideration of this legislation. I will turn it over to the staff of Representative Ballwig. Just to note that both Representative Ballwig and I serve as commissioners on MECs or MEC, and so that is why we have brought this legislation before you. And so we would be happy to answer any questions that you might have after comments from Representative Ballwig's office.
Thank you, Senator. Am I on? Representative Ballwig sent me to give her apologies that she's not able to be here today, but to thank you for holding this hearing. Joan was actually invited by the First Lady to join others from Wisconsin to present on the Fostering Futures Initiative at a Casey Family Foundation conference in Seattle. So thank you again, and special thanks to Senator Harsdorf and her staff for all the work they've done on the legislation.
Do we have questions for these two ladies? Any questions at all? Oh, Representative Berceau, excuse me.
I don't think your mic's on.
Senator.
I don't think your mic's on.
Oh, good. Senator Harsdorf, you may have read some of the testimony that's going to come up later regarding concerns about consumer protection. And I wonder if you'd address how that will be addressed under the new structure to assure that students aren't just left out in the cold with a lot of debt or whatever.
With a student complaint, there will be a process established by the board. And my understanding is that first, a student would go to the institution, and then if it's not dealt with appropriately or resolved, let me say resolved, at the institutional level, then it would get to the board. And we do have Jenny Parks is here from MEC, and she might be able to delve more into that specific issue. But it is a belief, I mean, right now, I believe that this will provide greater consumer protection for students, because I know I ran into one student attending one of our technical colleges, and she had actually taken some online courses from another state and actually had nothing to show for it. And so the challenge when you're taking online courses, if they're from an institution that's far away from where you live, how do you, as a student, try to work through that state, trying to resolve the complaint, and that institution that it can be hundreds of miles away across the country. And so this, I believe, will help ensure that students taking online courses have that process by which to resolve a complaint.
I look forward to hearing more about how it will transfer some of the current protections we've got and retain those for students.
Thank you.
Senator Bewley.
Thank you very much. I'll hold off some of the questions for MEC when they get here, but just by way of background, you are a commissioner, and Representative Ballwig is a commissioner, as is Dr. Foy. Well,
And Dr. Wiganki.
Dr. Wiganki. How are those people named? Is there?
Right, so there's 5 commissioners from each member state, And so those are governor appointees and then one appointee from each house of the legislature.
Okay, and this is enabling legislation, so if it did pass, what is the next step? Who makes the decision to apply?
The next step would be, we've established who would be on the board.
Mhm.
And so the application would be put together to MEC from that board.
Okay, so
That's
the,
my understanding. So the board would submit an application to MEC.
but is that a decision of the regents to say we're going to join, or I mean, how, not the
The system?
who decide, yeah, it wouldn't be the system, because the system is just part of it, I mean, this is enabling, so it doesn't mean we're going to apply, but somebody's got to say, yes, we're gonna apply.
I believe, Senator, it would be the parties making up the board, the DLAP board.
Okay, thank you.
And by the way, I did not include in my testimony, 36 states currently belong
Right,
to SARA.
Right,
They're
well-
regional compacts.
yeah, I've been to MEC, as we've talked about, and we are that gaping hole in the middle of the map, but I'll hold off the rest of my questions. Thank you.
Okay, thank you.
Just a quick question, Sheila. 36 states that are part of this group. If there's an issue in the 14 states that aren't, is there any way, how do we handle that? Or what's the,
If there's an issue in the 14 states, so what it means, if you are not a member state, and keep in mind, it's voluntary, like you said, this is enabling for Wisconsin to join. It's also, even if Wisconsin joins, which we are, there's no secret, we are planning on doing, it would still be voluntary for any institution in our state to participate.
okay.
And so what it means is if, for those states who are not members, as we are not right now, it means our institutions, based upon federal regulations, needs to go to every home state of any student that they are providing an online course to. That means literally potentially over 50 states that an institution would have to go to and get approval. So and there's a cost to that. And so,
Sure.
as there is a membership to this as well, but the point is when you have to go through and pay all those fees, it can be cost prohibitive. And in some cases, if a state is not willing to do that, it closes the door to that student to be able to take that online course in that other state. And so this is really about maximizing opportunities to students while we provide efficiencies and reduce administrative burden for institutions.
Okay, thank you. Senator Hansen.
Thank you, Mr. Chair. Just from the summary from the state of Wisconsin EAB, and I know they'll testify, one of the concerns they have is that it will erode the level of Wisconsin oversight and fundamentally alter the consumer protection of students enrolled in online degree programs. It's critical that efforts to reduce oversight of distance education are thoroughly vetted. Do you think that will happen? That's the question. That's one of the big concerns we have, as EAB has.
The consumer, or the oversight?
Yes.
And protection. I do not believe, and I know the EAB has had concerns with this from the very beginning. And obviously, this changes who oversees some of these institutions. And so it does impact the EAB, but I believe those issues have been addressed. I believe that there are some members of the EAB board who actually are supportive of us going this direction.
And a quick follow-up, Mr. Chair. if I may.
Sure, go right ahead.
If those 36 states, have they addressed problems that may have been created by the establishment of SARA in their states? Have they addressed those? Or do you have a history of those? It's in operation, 3 years? So 36 states have it. Do they still have some concerns going forward?
I believe, and Ms. Parks might best be able to provide some specifics on this, but I know that each of the regional SARAs, what ours is M-SARA, is under the NC, the National Council of SARA. And so I do know that they have, as issues come up, and I wouldn't necessarily call them problems, but as issues come up, they have made some modifications, or obviously it's a work in progress in some cases, and so as issues have come up, states are represented on those boards, those councils, and so they can bring forth issues that may need modifications.
Representative Hesselbein.
Thank you, Mr. Chair, and thank you so much for being here to answer questions today. I really appreciate it. So I'm concerned specifically what this bill will do to military veterans. I think it's no secret that I kind of look under that lens on a lot of things that we do in the state. Currently, they're protected against distance learning fraud at for-profit schools by the Wisconsin Education Approval Board. Won't this take away their protections? And I heard you just say before, and I just want to be sure that I heard it very clearly, that these for-profit colleges can either choose to join or choose not to join this new organization. What happens if they don't choose to join and they happen to be bad actors? And specifically, like our veterans that are using their GI Bill and they get in these awful situations, where are they supposed to go then?
So I hesitate answering this because I don't want to give you the wrong answer.
And, you know, if somebody else
And
coming
so
after you can answer, it's fine, too.
I would take us, I think I'm going to refer to
Okay.
Mac to answer that question.
Okay,
Okay?
that's fine.
Because-
Thank you so
Because
much.
we need the correct answer.
Thank you. I appreciate your honesty.
We'll try to make sure we get to that when the appropriate time comes.
Thank you.
Any other questions from any committee members? Seeing none?
Thank you, Mr. Chair.
Who's our next? All right, our next three speakers coming up together, Dr. Rolf Wagenke, President Ray Cross from the UW, and Morna Foy from the Tech College System. President Morna Foy.
I just gave you a little one-pager handout that's going to come around with some sort of background information that you're referencing.
Make sure the mic is on.
They don't show up very well, though, do they?
I'm just standing up, that's fine.
My name is Rolf Wagenke, and I am president of the Wisconsin Association of Independent Colleges and Universities, representing the 24 nonprofit colleges in Wisconsin and their 60,000 students. I have provided written testimony, which I will not read to you today, for the sake of brevity, and so we can get to questions here. But I want to give you an outline of what's in there and then touch on some of them. So the outline is as follows. I would like to speak on the collaborative process that brought us here today after 2 years of effort, the objective for creating a distance learning authorization board, the impetus for this legislation, the proposed solution, and some possible alternatives, which goes to the last question addressed to Senator Harsdorf. Suppose someone opts out, what happens then? So I'll try to address those. First, the collaboration. It's been fantastic. In a time when there's often a lot of disagreement, a lot of strife, Senator Harsdorf, Representative Ballweg, and others, the University of Wisconsin system, and Dr. Cross, Dr. Foy at the Technical College system, and our people, we have really worked together for 2 years, including working with the Midwest Higher Education Compact staff, to have the best possible outcome. The complaints we've gotten to date are what's taking us 2 years. And the 2 years where we wanted to be sure that we addressed concerns such as consumer protection, that we protected also the state government's prerogatives to govern itself. There's always concern when you do something regionally or nationally, what happens to the authority vested in you, the legislature, as in the state constitution. So the collaborative process was long, it was intense, but I think we came up with a good outcome. The objective is to have a non-bureaucratic, cost-effective mechanism so the state can innovate in distance education, be involved in it in a nationwide trend, and protect students as they pursue post-secondary degrees. The impetus, as Senator Harsdorf said, was the federal government. The federal program integrity rules came out in 2010, and they basically said to every post-secondary institution across the country, if you're going to offer distance learning, you have to go to all 50 states and register your program, comply with those states' laws, pay the state fees, which can total tens of thousands of dollars, so that's the dilemma we're faced. We heard from public and private universities this was a burden. It caused some universities to actually drop distance learning programs because they didn't want to pay those fees, not that they didn't want to have protection. So the federal government was the impetus, and the regional higher education compacts. Wisconsin has belonged to MEC since 1994, and I've been a commissioner ever since. So we had a say in coming up with this solution that, again, would be cost-effective and protect students. The solution is creation of a board, the state authorization reciprocity, no, the distance learning, distance learning authorization board attached to the higher educational aids board, which would authorize institutions who wish to participate in distance learning to offer that learning and to provide a follow-up complaint process. In effect, the complaint process is already in place. This adds another level for the students to take with their complaints. Now, all the sectors, the University of Wisconsin, the technical colleges, and WACU members have developed a complaint process template, which is on all of our websites. You can all go and look at anyone's website, and that template says to the student, this is where you go if the institution is not resolving your complaints. So, for example, if a student has a complaint about false advertising, they first go through the existing channels, let's say at the University of Wisconsin system or at the Educational Approval Board. If they're not satisfied, they can then take it under, if this legislation is enacted, first, I should have said they can currently take it to the Consumer Protection Division and have their false advertising complaints addressed there. And now the new proposal would be, if they're not satisfied with that, they can take it to this board. So it adds a new level of protections for those those students who are participating in distance learning. The reciprocity part of this agreement says that if the student is taking an online course in another state, they will have access to that state's complaint process as well. It does not change any of the existing entities, including EAB's authority over Wisconsin for-profit institutions. So EAB will continue to regulate Wisconsin for-profits, and let's pick on Minnesota. Minnesota will regulate and provide access to Wisconsin students taking online courses from a Minnesota headquartered institution. And there again, there's a clear process which will be spelled out. And we think, of course, in Wisconsin, I believe it's true that we have a quality system now. And all states who participate in SARA will have to come up to the SARA standards for protecting students. So Minnesota does a good job. For example, they were the first to, I believe, to address some abuses that were identified at Globe University. And so Minnesota does that, and our students will have access. And again, with the National State Authorization Reciprocity Agreement Council, they will set the standards for those complaints. And so I think in the end, at the end of the day, it will be an improvement. I want to move to what alternatives would be if we don't join. The status quo would say if we don't join, then every institution is going to have to go on their own to all 50 states, with again those costs and the potential of a loss of educational opportunity, because frankly in some cases it's prohibitive. If we're going to go to those other states, it's cheaper for us just to say no, we're shutting down the course, which would limit opportunity for our citizens. The other alternative, which has been proposed, and frankly it's unconstitutional, Wisconsin could seek to regulate online learning that originating in all of their states. I mean, it's been proposed we can't, under the U.S. Constitution, one state cannot regulate the others under the Commerce Clause. And this has been proposed, and we frankly have resisted it, we could let the federal government take over regulation of higher education and get the state out of it. And we think and believe, and I think we are right in believing, that Wisconsin does it better than the federal government would ever do it. One thing, going back to the limitations, this legislation, and something we're all particularly proud of, makes it clear that this state authorization, the Distance Learning Board, will not have a say over curriculum, over finance, over admission standards, over graduation standards of any institution represented at this table, or institutions regulated by the Educational Approval Board. So this is not a power grab by this board to regulate others. Also, a provision that I'm very proud of is that in this legislation it makes it clear that student privacy laws, whether federal or state laws on student privacy, are not overridden by Wisconsin joining the SARA reciprocity agreements. So all the protections for student privacy remain. I said I'd be short. I'll turn it over to Dr. Cross now. You want to sit in the middle, Jim?
Good morning. Let me begin by my remarks by offering a few words of gratitude for my colleagues here, and also to Representative Baldwin, excuse me, and Senator Harsdorf for taking the initiative to lead this effort. We think this is really important for the state, and we urge you to support it. I also want to thank Paige Reed from our office, who served as legal counsel, for working with MEC and others to put this together. So, Paige, thank you. This has been, and I won't repeat what my colleague Rolfus articulated, this has truly been a collaborative effort between us, and it's taken us quite a while to work out a lot of these details and put it in front of you, and we appreciate this. In our case, this is going to help us tremendously, and I'm thinking about, in particular, the ability to compete in other states and offer to people in other states what we have to market in terms of higher education, and the cost that would, if we do not create this, the cost that would impose upon us would be almost prohibitive. And furthermore, it would limit our ability to be creative and do other things, such as expand our efforts in competitive or competency-based education, which I think has an incredible future. So without this bill that cost us both time and money, Michigan and Alabama, for example, are planning on charging any non-SARA school $10,000 in fees for the first year for each institution, and $5,000 annually thereafter. And I think that's going to really pull a lot of people back. That seems excessive. It would also make it easier, however, for other states to come into Wisconsin. We actually welcome that. We think we can compete on quality and price very nicely. So please, we welcome that. I think it also drives innovation and also creativity. One of the things I mentioned is not just the cost, but also the time. And I want to give you an example. At Stephen's point right now, the person who handles the coordination of distance learning for other states spends about a third of their time negotiating these deals with other states. That's not registered in the cost to us at about $162,000 over the last 3 years. The time that it costs a person at each of our institutions to make sure we're complying with the requirements from other states is not even in that 162,000. So this will really help us clarify that, simplify it, and I think help Wisconsin become a part of what's going on nationally. Yes, there are 36 states. There are probably another 11 that are ready to go. So if we don't do this, we'll actually be one of 3 states, not 14. So I urge your support for this and appreciate your willingness to do this. Thank you very much.
Thank you, Dr. Frost. Dr. Ford? Can you hear me okay? Nice to hear. Okay. Thanks again for hearing this bill. I too want to say some thank yous. They're really, we're representing our systems here, but there were obviously some other folks who did most of the heavy lifting and talking about and working through a lot of these issues. In addition to Paige Reed, Nancy Merrill from my office, Brooke Froelich from the Senator's office, and Rebecca Larson from Wake, who have just put in tremendous hours over the last couple of years trying to get through a lot of the issues that we brought up today and that we've brought up. And I'm going to be very frank with you. I was not a fan. Some people, including probably Jenny Parks here from Met, as Senator, I know. My colleagues here might say that I was actually the big stick in the mud when we first started talking about this. I didn't like the idea. I don't like going outside of our system and our state that much. And I thought there were a lot of issues that were established as part of the original agreements from the national and the regional compacts that seemed to take away autonomy and authority from the states and from our individual institutions. And I wasn't comfortable with those things. But the last year, I now have been serving on actually the NC-SARA steering committee for this region, which means that all applications from the other states to be a part of this project, I've been part of that review and approval process. And seeing the way other states have addressed the requirements of SARA, because it's a single process. When we say reapplying, I think somebody asked the Senator, how does that work? It would be DLAB that's going to apply on behalf of the state of Wisconsin. This bill would give them permission to do that, but it's not a unique application. It's a very structured application. You have to demonstrate these things, one of which is that you have a portal entity like DLAB in place. But as I looked at these other applications and the steering committee talked about how is this proposal going to address the needs of SARA, a lot of my concerns have been addressed. And I think this bill makes it very clear that those things are not going to occur here. For example, the specific design of the portal entity. I think originally there was some idea that it would be one way of doing it. Every state would do it exactly the same way, and that is not how we are set up in higher education organizations. So we're all doing it slightly different with the same goals, the same powers, but our collaborative arrangement is, I think, fairly unique, and that's okay. There was some concerns about how were student complaints going to be handled. And would this mean now that students were going to be left to fend for themselves with the institutions in other states? SARA, in fact, puts new student protections in place because in the past, there were no portal entities to act as go-betweens that had higher education professionals on them that could help sort of facilitate a conversation between a student and an institution that they were going to. And so I'm feeling much better about that we are actually adding to the protections for students. There was also some issues about how much of information we'd be required over time to be supplying to these other entities. And that has also been addressed now. We're talking very specifically about distance education and distance education activities that are going across our states. As Rolf mentioned, the FERPA student protection requirements are all in place, and they won't be affected by this. I have a whole list of reasons why I think this bill is a good thing to do. I think they've been articulated by my colleagues here at the table. But one additional one, which hasn't gotten talked about that much, is that in addition to saving us money, the current system that the feds have put into place that require us to seek approval and pay a fee to every other state that we might be providing distance education to one of their citizens, it also gives them authority over our curriculum, over our program design, and over our higher education product. And I find that very unacceptable. And I think our colleges, my colleges, have found that unacceptable, and it's been very recently a real barrier to them being able to offer distance education opportunities to students. And that is something that is corrected in the SARA process, because by participating, by agreeing to set up portals, by agreeing to have a more facilitating joint effort in protecting students, every state is also acknowledging, which frankly Wisconsin always did, that public higher education institutions, nonprofit institutions that were accredited, that we are legitimate, high-quality providers of distance education. And that is now recognized in the SARA program. Every institution, every state is recognizing that about their fellow states. It doesn't exist without SARA. It's not just that we have to pay them a fee. They get to sign off on what we're teaching in our classes. And that doesn't work for our institutions. I'm sure it doesn't work for my colleagues' institutions. And that's going to be corrected now under this legislation.
Thank you, all of you, for your testimony and sharing your thoughts. You know, a lot of work has gone in over the last couple of years, and I want to thank you and your staff as well as Brooke in my office, because there's been a concerted effort to address the concerns that were raised early on, to have a consensus on this is the right direction to go, and make sure that the legislation before us will allow us to apply and become a member state. So could you address the issue of, I know there are we have a tendency to look at how we can amend and make things better in the legislature, and that's an important part of the process. But can you address our need to have legislation that meets NC-SARA's requirements in order to become a member state? Because I know this has been an issue in some of the other states. They pass legislation, and then once it's passed, it doesn't meet certain requirements, and then they have to go back. So could you address that?
You're absolutely right. It did happen even with our neighbor Iowa, who went through the whole process and then had to start over again, which is always a setback. This legislation, as we drafted it and reached consensus, we were in communication with MEC several times to make sure we would meet the standards. Again, not to roll over, but to make sure that it was appropriate. And the ultimate safeguard does also come back to the legislature, because we can't apply without going through a passive review process with joint finance. So again, we want to make sure that the state constitutional prerogatives for governance were acceptable. So we will work on an application for us to join. Then it goes to joint finance for their review, and I know all of you have, even if you're not on it, certainly have access to that. And then it would go to MEC for their consideration. The one example, for example, that is in the national criteria is providing for equal treatment for institutions in all sectors. So the University of Wisconsin and, let's say, Marquette University and Western Wisconsin Technical College and for-profit institutions all have to be treated equally. So there can't be a particular carve-out for UW or a particular carve-out for the for-profit institutions. Equal treatment, so concerns have been expressed that we went through in this 2 years. Well, will the powerful and influential institutions run roughshod over their competition and less powerful? And the answer to that is no, because we would lose the protections for everybody if we did that. That's an example of kind of fair criteria that MEC has built into the SARA agreement in the process.
I would just say, Senator, this is a classic example of how, when it is a good thing not to be in front of the pack. And we have gotten to learn from other states' trial and error. And I think NC-SARA and MEC have learned from that process as well. One of the issues that was problematic in the Iowa legislation was a clear distinction between the consumer protection and student protection authorities of the portal entity and their existing consumer protection functions in the state, for example, the Attorney General or their Department of Consumer Protection, whatever they call it. And it really helps to have those things delineated and to be recognized in the statutes that those authorities remain and are still protected, but that this portal entity exists. And that is really, for us in Wisconsin, that was a big part of having this legislation, is that we didn't have a portal entity in place. And we are doing something kind of unique by having a collaborative entity. And the legislation is necessary to establish that. I don't want people to think that the collaboration is unique, though. It actually is possible because of the long history we have of working together across systems. The Higher Educational Aids Board is the most clearly established, partnership between us, these three systems, the tribal colleges, the private institutions, but you also have our work on veteran services and the portal that we have for veterans information and work that we're doing to provide the veterans tuition remission across the UW system and Tech College system. You have our transfer agreements and the transfer information system. You have our work on the longitudinal data system for students with DPI and the Department of Workforce Development. So we have, I believe, some very front-seeing leadership role in terms of partnering between higher education and education systems that's unique in the nation. And that's why our portal entity and the way that we're approaching NC-SARA and MEC is also kind of unique. And it took more time to put it together.
Thank you.
Senator, and a question was asked before about veterans and again the EAB. All of those protections that exist now for veterans stay in place. They're not affected. It provides an alternative for appeal for those veterans who are students. But everything currently in place stays in place for the veterans, or as far as their governance over Wisconsin institutions.
Thank you. We'll open it up for questions, and first we'll go to Representative Petrick.
Thank you very much, Madam Chair, and thank you for bringing this legislation forward. Really appreciate that and all your hard work of your staff, and thank you all for your input in getting this up and running. I did have perhaps a question that you could enlighten us on some of the specifics, if possible. In Section 5, referring to fees, it seems that the language is a bit broad. And it says with any function, you can establish reasonable fees to be imposed in connection with any function or service. So, two-part question, perhaps, what do you envision the administrative fees might be, and perhaps enlighten on what functions and services it would be necessary to charge these fees for. Has there been any discussion? If not, fine, but thank you very much.
There has been discussion. We began, and for the startup here, we have agreed, three of us, to front the costs. And we believe we can administer this without state tax money, perhaps without state fees. The advice, though, we got from council is you don't know. So the fee provision as drafted here is intended to be backup, but these three organizations have agreed that we will, out of existing resources, provide staffing and develop the website and everything that needs to be done.
Representative, I can tell you, being on the steering committee, every application I've seen from other states, they have established, the portal entity has established a fee for the institutions that want to join SARA. So again, institutions will be free to decide whether or not they want to be participants. And so they would pay a fee to be a part of NC-SARA, and they, in most states, would pay a fee to the portal entity. Right now, we haven't established such a fee, and Jenny, if she testifies, might be able to give you the range, but I think it's anywhere from like $2,000 to $4,000 or $5,000 in
Per
other
institution?
states. Per institution annually. So it's a processing fee. It could depend. Some states are basing it on the size of the institution, the activity level, but it's not some huge amount, and it would be to participate nationwide as opposed to paying fees that are probably more than that in individual states.
Okay.
And again, on an annual basis. So.
I think our intent is this is cost only. If there's cost there, we're trying to absorb it in the beginning because we really don't know what it's going to be, but trying to be as efficient about it as we can.
Certainly.
Yeah, just to follow up on Dr. Foy's, so there's two different possible fees. One is the fee to SARA, and that would be per institution, and it's based on enrollment, and it's under 2,500 FTE, it's 2,000. And then there's 3 levels, and the highest level is 10,000 or more FTEs would be 6,000. And then from 2,500 to up to 10,000 would be 4,000.
Is that in the draft?
That is not in the draft.
Okay, thank you very much.
Because that would not be in statutes.
Gotcha.
That would not be, that is an NC-SARA fee. Okay. And what is in this bill is that these entities will be responsible for staffing. So it is their hope that they can absorb those costs.
Okay, thank you very much. Very appreciate that. Thank you.
Other questions? Representative Hesselbein.
Thank you, Madam Chair. First of all, thank you for being here. You did answer a lot of my questions today just with your testimony. I appreciate it. And I agree with all of you that Wisconsin does do it better. So I do have some questions on that. Last year, Corinthian closed down, DeVry closed down in the Milwaukee area, and I think it was affecting like 247 students. So the EAB that is self-funded was really in charge of trying to figure out what was the best for those 247 students. Would they be getting their refund? Were they looking at alternative courses? Where were they going to go? So what I have questions with is, what if we have 100 students taking some online course, and I'm going to pick on California because their cows aren't happy, but so let's say it's a California thing, and we realize that something really terrible is happening in California. What's going to happen to those 100 students? Who's going to work with them to make sure they get refunds or different programming or something going on?
Well, let me be clear that what EAB did with the
If you want to speak into the mic, I'm sorry.
what EAB did with Corinthian and other schools here in Wisconsin that are operating here in Wisconsin, they are going to continue to do that good work. They have to do it. Right. This makes no difference to those students. As far as students in other states, right now, other states, if you're not a part of SARA, you don't have access to the portal entities that are in those other states, and we don't have a portal entity. So those entities now are new bodies that give students a place to go when they're working with that individual institution. Because you have to understand, all higher education institutions, under federal law, we have an obligation to our students. And we like to believe that we honor those obligations. Now, Corinthian obviously didn't feel that need to honor it, but in the past, the student was kind of at their mercy because they were in California and they were taking distance ed. And even EAB could act as a facilitator for them, but they had no authority. Now California, where Corinthian is mostly housed, has a portal entity, or will have a portal entity that is going to hold Corinthian to its own. If Corinthian decides to join SARA. If Corinthian doesn't decide to join SARA, it's just the status quo. This is not a force for institutions. I have every expectation that some of my colleges will join as soon as it's absolutely possible for them to. Others, they're not going to. They don't do that much activity in distance education, or they have other priorities for their funds, whatever. But for institutions, private, proprietary institutions that join SARA, they are basically going to be subjecting themselves to a new oversight entity that did not previously exist.
Thank you, that helps.
Dr. Cross?
I'm not sure about this, but I want to check with my colleagues here. I believe HLC now requires that institution that closes has to provide a backup plan for students who are in. Is that correct?
They always did.
They always did?
They always did, but Corinthian wasn't accredited by HLC, that's the
That's
problem.
my point.
Okay, thank you.
Okay, next we have Representative Quinn.
Thank you.
No,
Thank-
Representative Quinn.
Oh, Quinn.
I'll put you on the list though.
Not Bernier, Quinn. Thank you, Madam Chair. Your answer to Representative Hesselbein's question kind of touched on what I was going to ask specifically. I'm just looking ahead into the Educational Approval Board's testimony, and part of their testimony says that students in distant learning programs at out-of-state institutions will not have the consumer protections and student complaint resolutions currently provided by the EAB under SARA. Now, I think I heard just now, would they not have those protections because SARA is in place then, or could you comment on that?
They would have them from their home state. The home state of the proprietary school.
Could you use the microphone, please?
I'm sorry. The protections would be from the headquarters, the state where the for-profit provider is, and those requirements would have to meet SARA standards. So they would have protections. For Wisconsin-based institutions, it would be through EAB, unchanged.
Perfect. Yep, thank you.
Next we have Representative Billings.
Thank you, and thank you for your testimony. I'd like an idea of current numbers. How many people are we talking about with distance learning currently, and what do you see in the future, and how would this legislation affect it?
Are you talking about students that are in Wisconsin that might be going to
Yeah,
other
yeah. What do you have
institutions in the
now
state?
currently for distance learners? Like President Cross talked about Stout and the work that has to be done there to make sure that we can have agreements with other states. So how many students are now doing distance learning, and how do you see the implications of this? And then I have a second question too.
In my old age, I'm losing my memory. Just last night I read that number and I can't remember it right now. It's in the last. I'm gonna paraphrase this in a relatively correct but not accurate. It seems as though in the last 5 years that distance learning participation has increased something like 5-fold. And I don't know the exact numbers. It just seems like that multiplier remains in my mind. What we do know is that 85%, according to national studies, 85% of college students today are considered in the traditional, non-traditional model, non-traditional students. What that suggests is that I think 1 out of 4, even though they're in a full-time campus environment, are taking an online course. We're seeing an enormous growth in not just the delivery of separate online courses, but the hybrid use of those courses with faculty who are teaching in a traditional mode. I can't recall the exact numbers in Wisconsin, but I know they're growing in the University of Wisconsin system, and I suspect that's true with your campus.
We have over, I think it's close to 15% now of our students are taking some kind of distance education. And I think it's about 28,000, I want to say, is the number last year that took some kind of online. But that's our students.
Right.
So it's not, I don't know if there's somebody else's students in other states. I don't know. I don't have data on them.
Well, I'm most concerned about our students, so that's good
Right,
data
but
for me.
I think our students, the college students who are taking online learning, for the most part, are taking it from technical colleges here in Wisconsin.
Mhm.
So that, I don't know how many of them are taking it from other states.
And what do you see the future implications of this legislation?
Well, for one thing, I think it's going to strengthen our relationship across higher education institutions in this state, because when you have to actually deliver a service together in partners, it builds stronger relationships, and that goes well for a lot of things that we have to do in the way we deliver. think the other thing is that nationally, this whole idea of how do you regulate the whole world of the internet, it's very complicated. And I think actually that higher education is sort of on the forefront of how do we do that in a way that provides protections, consumer protections, but also allows us to be operating out in that marketplace without a whole bunch of very paralyzing regulations. Can we trust things like our own accreditations across states? Can we trust governing bodies from other states to do their job? And MEC gives a framework for that, and it could be, I mean, I think there's a possibility that it's a model for other things like commerce, and how are they going to do it across states and in the cyber world of activity. So, you know, is it perfect? Probably not. Are we going to evolve and change it over time? I would guess so. But that's because we are operating in a whole new marketplace right now. And the old ways of regulating and overseeing and delivering those services is changing, and the internet has changed that.
May I comment on that as well?
Absolutely.
I think Morna said something earlier that I didn't mention that I probably should have, that's really important to us. It isn't just the cost or the expense. It's another state dictating to us what we must change in our curriculum. And I find that really disconcerting. And I suspect you do as well. We work carefully, and our faculty work carefully to develop not only the curriculum, but the methodology or the pedagogy to make that happen. And to have another state say, no, we don't like that. They may be right, but I would argue that I'll bet on our folks. Secondly, I would also argue that has an homogenizing effect. Oh, we think this curriculum should be like this because 47 other states have that. Oh, wait a minute. What makes higher education in our respective institutions strong is the differences that are in many ways our strengths. So I would not want to homogenize our curriculum nationally. I think that's inappropriate for most programs.
And I have a second question on accountability. I've seen those numbers of students and debt and problems, especially with institutions like Globe University that you referred to, Dr. Wagenke. Did I pronounce that correctly?
Yes, you did.
I got Waiku wrong last time, so I want to make sure I got your name right this time. So I have special concerns about that situation. That we already know that's an issue within our state, and to expand that makes me concerned. So what happened in that situation with Minnesota and Globe that you referred to earlier?
I don't know the outcome. I'm sorry, I don't know if they've settled that or not.
But there was an incident with Minnesota with Globe University. There's already been issues that have come out of the SARA agreement.
And I don't know whether they've been sued. The Globe University, as I understand, has been sued. I don't know how the outcome of the case, and it was, as I understand it, for misrepresentation of job prospects and the quality of the degree. And so my point in raising that was that Wisconsin students, if Minnesota has already joined SARA, would have the advantage of Minnesota protecting them as well, because we recognize the other regulatory regime.
Okay, thank you.
Next, Representative Bursell.
Thank you. Am I on? Is this on?
Yeah.
Okay, now it's on. I'm addressing this to all of you. In my district, I was invited recently to a small IT college that has opened up, and one of my questions was what what sort of protections do these students have for the money they're spending, that this degree will be recognized, et cetera, et cetera. Related to that, I am wondering, how do you have ideas on how we start getting students to understand that there are different protections or lack thereof based on choices they make for online? And I'm not sure how we would get that out there, but I know if I buy a product from a private seller versus a store that I don't have protections. How do we get that knowledge out to students that when they decide to take an online course, that they may or may not have protections that they perhaps expect, being used to institutions of higher learning, being grounded in rather, regulated environments?
Well, I don't want to.
Please use your mic.
Sorry, I don't want to sound making me joke, but it's an education process. It's
Yeah,
just
I realize,
the
and I'm
same
wondering, how
process
do we
with
do that?
educating about debt. The truth of the matter is that private, proprietary institutions, whether they're operating online or whether they are operating physically here, they go through a different accreditation process than our institutions do. And that is something that is, in the past, you couldn't put that on your advertising. You couldn't say we're an accredited college because they didn't go through the regional accrediting bodies. They have created national accrediting bodies so that they can say that, but they aren't held to the same standard. And it's a challenge. Everest, we don't have to go to Globe in Minnesota. We can look at Everest in Milwaukee. They were a private Corinthian school. They operated in a way that I don't think was in the best interest of students. And I know that Marquette, UW Milwaukee, and MATC made a concentrated effort to try to reach out to their population in the city about what their institutions had to offer and could provide, as opposed to what the awesome advertising and amazing brand new building that Everest was selling. And for the first couple of years, it didn't work. We had lots of students in the Milwaukee area choosing to go to Everest. And when they didn't get what they were promised, we have all worked as institutions and as systems to help those students find a new place and a new path. But it's painful, and it's one of those things where we just can't let up on it. I mean, SARA is not going to be the solution, and we're not pretending it will be. We have to keep talking about the truth of the matter is there are proprietary institutions that do right by their students. They might be expensive, but students get good degrees, they have flexibility, they have something to offer a student, that's why they went there in the first place.
Is this something we need high school guidance counselors to be talking about as one way to help
Great
students
idea.
determine? Thank you.
Just as a follow-up, one of the things I think SARA does is the federal government, in its program integrity requirements, is what really prompted a lot of this, because of the inconsistency from different states, and hence you're going across state lines. So this state does require that you post employment records and you perform. Other states don't. So this brings some requirements to program integrity that didn't exist before. That doesn't solve the education problem or the communication problem you're suggesting, Representative Purcell, which I think is a really good point. And I like the suggestion about high school counseling.
Okay, Senator Bewley?
Thank you very much. As this is sort of gelling in my head, something that Dr. Foy said before about the EABs prompts me to ask this. Is it accurate to say that with SARA, we need the individual state EABs and their account more than ever, because their responsibility remains intact, and that is it is the state's integrity, our state's integrity of its institutions that the EAB is sharing with the rest of the world, with the rest of the students across the country? Is that?
I think that's part of the reason Educational Approval Board ought to be on this board. Because, yes, they need to be part of the entire process here, and has particular challenges. And so, in our view, yes, they're important. They're an important part of the process.
Yeah, and honestly, EAB's regulation of proprietary institutions that are here, to me, is critical, and nobody else is doing that and can do that work.
And then there's a counterpart in California that will do their schools, and there's a counterpart in New York that will do their schools. So every state needs to have that. So, okay. Another question that I had, and you've all referred to this, since this is enabling, we don't have a fiscal on it. So technically, we know that it could save money. And Dr. Cross, you mentioned some of the figures that would. We're always thinking about our students, the cost of education, student debt, that's all. Will this have a significant cost-saving effect? And is there any way that you can put that into some terms that make us understand what this might be able to do for savings?
I will try. The last 3 years, we've spent $162,000, just a minor error and zeros there. $162,000 just institutionally paying fees. We know we can at least cut that in half. And also, what we can't quantify easily is how much time so many of our staffers are working on this. And I think that's really important. And that's a big piece. Clearly, all of my institutions that want to participate in this, because they're doing a lot of distance learning, distance education, will want to do this and are pressing me to get this done. This is important.
Yeah, Senator, I would just say that for the institutions in my system that do this, they're now paying, $4,000 a pop per state that they're in. That could be for 3 students. It doesn't matter how many students they're serving, that price is still the same. Plus, they're subjecting themselves to all sorts of other overtime. And this, we're estimating the NC-SARA fees, if every college in our system were to apply based on their enrollments, it's about $52,000 a year. But then that covers them for everything, as opposed to 4,000 or 5,000 per state that they want to be in, multiplied by 16. So I don't see how it could not be cheaper for the institutions.
Senator, there is a fiscal note also in the bill file. Yeah. By the Higher Educational Aids Board. Other questions of committee members? Hearing none, thank you very much for your testimony and for being here today. And I'm sure each of you will be available for additional questions that committee members might have. Next, we have up Jenny Parks from the Midwestern Higher Education Compact. And Jenny will be speaking in favor.
Good morning, everyone. Thank you for having me here, and it's a delight to follow our 3 previous speakers with whom I've worked now for over 2 years, trying to make sure they have all the information they need from all the other states, that they have the information they need from MEC, the Midwestern Higher Education Compact, and that you get everything just right as you begin to think about stepping into SARA in Wisconsin. And I do have to say, this bill is particularly tightly written. It's impressive. When I read it, I thought, wow, this is polished and well done. And it does enumerate a lot of the specifics that in previous bills in states that have joined previously were not addressed. So again, I applaud you, and I'm glad that you brought that up as a point this morning. So as I said, I come from the Midwest Higher Education Compact. I believe there should be just a quick infographic going around about our organization.
We are one of 4 higher educational compacts that function in the U.S. As you might be aware, that compacts are actually enumerated in the Constitution. They are this strange level of a quasi-governmental entity that allows states to assign certain powers and certain obligations to an independent third party. And probably the one that you don't think about, but with which you are most familiar, are some compacts that allow you to drive from one state to another with the same driver's license. The states agree to all do certain things to authorize someone to be a driver, and therefore you don't have to, when you roll across the line into Minnesota, stop and have another driver's test and do things there. Well, that's not unlike what the state authorization reciprocity agreement is advocating, is that each state does have an entity that can verify the export of its online educational services. The current model, or the traditional model, is that every state authorizes every individual import of those services versus one body in the state with an existing and close relationship with its own institutions and with physical jurisdiction over them because they are domiciled in the state. They authorize the export of those educational services. The compacts rose to the challenge of taking on this problem across the nation after it was determined that we talked a lot about the program integrity rules. Those came out October 29th of 2010. It's burned into my memory. It's a day that shall live in infamy, to quote another one. It really did send the higher education community into a tailspin. We now know that more than 60% of all courses are offered online. It is the fastest area of growth in both programs and actual courses that students take. And it is, frankly, the future, as the bulk of the students in this nation are now coming from what would be called a non-traditional background. They might be returning adults. They might be adults seeking education for the first time. We have a huge military population that is exiting service and has a GI Bill to apply to many of these courses. And as we become a society that is not place and time bound because of the internet, education is following suit. And it is the way that even traditional students who are recently graduated from high school, you have to think about it. When they think about shopping, they think about sitting on the sofa in their sweatpants and logging onto Amazon as much as they would think about driving down the road and going to the grocery store or going to Target. And that is, both in a non-traditional sense of students and in a traditional sense, the way that a lot of education is going. So it is important to rise to the challenge to figure out how do we get a handle on this. I know Senator Billings had asked for some numbers. Well, one of the main things that SARA accomplishes is for the first time we're going to have some numbers about the traffic, if you will, of interstate higher education online. Currently, we don't have numbers. IPEDS, the Integrated Post-Secondary Education Data System, every 2 years collects a few fields about online education. They've only done it for 2 cycles now, and so they're still trying to tighten up their definitions and tighten up the way they collect that data. But in general, we don't know. Whereas one of the key components of the SARA initiative is to gather that information from each portal entity, from the institutions once a year. We should, by this fall, have the first time that we will know how many students in Wisconsin institutions are serving students from another SARA state. And we'll also know from all those other states and their institutions the same. And that's all aggregate data that would be put together and shared with everyone. So this also moves us forward in our knowledge of what we're doing so that, again, we have a handle on it. We understand the magnitude and the directions. It's also important for policymakers such as yourself, because knowing that, wow, we've got a lot of students going out of state for this type of a program or to this other state, maybe we should think about opening another nursing school. I mean, why should they do it online in Illinois if we can give it to them here? Or, we don't have many students still attending this one program, but they've got great programs right across the border online in Minnesota. Maybe we can shift some of those resources and make good choices about our higher educational spending. So there are a lot of ways that just the data and the information that you're going to get from SARA will be helpful. But I do think today, and it seems to be the theme of the conversation in most of the states where I've testified, is the issue of consumer protections. And I see why Wisconsin thinks about that. You have to understand, I went to school in Madison, I graduated from Madison. My daughter is a senior this year at Madison, and I live in La Crosse. My office is in Minnesota, but I call my home state Wisconsin. And so this is very important to me. And I do know from my interactions with David Dees at EAB, and just from having worked in institutional research in one of the system schools in the past, I'm well familiar with our love affair with data in Wisconsin, and I know how well we do it. In fact, one of the big shocks to me when I did start talking to institutions in other parts of the country about data was I brought the wrong set of assumptions to the table. I assumed that everyone did it as well as we did. Well, they didn't. But one of the things SARA asked them to do is to bump up their data efforts and to make sure that they're doing very good record keeping and tracking of student activities. So I think it's important to know those things, but the consumer protections, once we have that data about students, we know how to take care of them. The best thing about SARA, I think, is the protection it offers a student who, let's go back, I won't use California yet because California has not yet joined SARA. They're interested, for those of you who want to know the status of that huge state. But they have many moving parts, and so they are very interested and they're moving forward, but it's going to take a little while for California. We can use Minnesota, everyone's favorite, We will, let's say you've got a student in Minnesota attending an online school in Wisconsin. Now, traditionally, that would have been regulated and overseen by the EAB, and if there were a problem for that student with the school in Wisconsin, it would be very difficult for that student to know exactly where to go. Well, do I go to the Office of Higher Education in Minneapolis? Do I go to EAB in Madison? What do I do? Or do I go to the Attorney General's office? I don't know what to do. It's very clear in SARA what a student does. So let's say the same student just starts calling and calls the portal entity in Minnesota. They're going to say, oh, well, that is a Wisconsin school. So here, I'm going to give you the DLAB complaint link, and I'm going to give you the DLAB contact information. Then that portal agent would also call DLAB and say, hey, we've got someone who's got a complaint. Let's work together on this. And in fact, that's how it's been running now for a couple of years in SARA. Quarterly, we collect information from all the portal agencies on any complaints that rise up to their level. So far, it's been very few, about 2 or 3 in each of the regions. And in all cases thus far, they have ruled and enforced it in favor of the student. So we do have a system so far that is working, and we intend to keep improving it as much as we can. And we do learn as we go along. There is a process that was just approved at the December 1st meeting in Denver of the National Council. We now have a unified agreement. All 4 regions operate from the same functional document. And a prominent feature of that document is the process by which states, institutions, or regions can escalate a very important concern up through the process and get it entertained by the actual National Council. So if there is something that needs to be addressed, there's a way to do that. Also, we try to make ourselves very available at MEC. That has been one of the specific strategies we have used, is to keep in constant contact with all of our institutions and all of our state reps to make sure that we are also monitoring this process. And we will not discontinue that. We will continue to have a very central role in that, not the least of which will be our regional steering committee. That is the entity that approves and reapproves each year a state's membership. And it is also an entity that can take a complaint about the state portal agency if such a complaint is warranted and rises to that level. So I don't know if I've told you enough to move us forward, or if I can just start answering questions. I tried to write them down as quickly as they were coming, and I don't know that I captured them all. So I am kind of hoping that all of you have kind of kept the questions you had for me and can ask them now.
Thank you, Jenny. Just to clarify, obviously student privacy is an important issue.
Absolutely.
And in the data collection, because this was something that received a lot of discussion and
Yes,
a lot
it
of
did.
concern from our Wisconsin stakeholders and institutions as far as maintaining that as the data was requested.
Mhm.
So the data that is requested and would be requested through SARA, that contains no personal identifying information? It's all aggregate?
All aggregate, and in fact, cell size is lower than 10. We request that you report that as a 0 so that we could not identify small numbers. So if a Wisconsin SARA participating school is submitting its annual data and had fewer than 10 students online in Hawaii, you would report that as a 0. I mean, we are trying to really go above where the FERPA standard is, and in fact have taken all of our data requests and we run them through our council, NC-SARA's council in Washington, to double check that they are in FERPA compliance, but also just to make sure that all the institutions are feeling comfortable with the sharing of their data.
Okay, thank you. And then, I think you just touched on it briefly. If there are issues that come forward, every member state has representation on the council?
On the steering committee. There are 21 members of the NC-SARA council, so not every state can have an individual representative. But on the steering committee at MAC, I can tell you every member state has a representative, and then we have 5 at-large members. That's how Dr. Foy is a member of the council right now, because we did think it was very, very important to use those at-large memberships to bring in members from states where we did not already have membership. So she's been a huge asset to us.
So can you walk through the steps then, if Wisconsin's a member and if there is something in NC-SARA that they believe needs to address, what would be the process that would bring it to NC-SARA?
Sure. The first step would be for someone either to contact me, and I would bring it to the regional steering committee, or for anyone who has a serious concern to bring it to a member of the regional steering committee. All of their contact information and their names are on the MEC website, and they are linkable from the NC-SARA website. So either through MEC or through one of our steering committee members, you can bring it to the steering committee, and then the steering committee will begin to research it, chew on it, consider it, and possibly kick it upstairs to NC-SARA.
Okay, thank you.
Sure.
Questions of committee members? Senator Bewley.
Just because I'm curious, the map has the 1, 2, 3, 4 regional. What about Pennsylvania, New York, and New Jersey?
Oh, good question. Those are the 3 states that have never joined a regional higher ed compact. Interestingly, for most of this SARA process, all 3 of them have now begun to entertain membership. And for the first year and a half of the SARA initiative, I actually was in some negotiations with the folks in Pennsylvania because they wanted to join with MEC. They have now decided to join with SREB because of their K-12 work. MEC does not do K-12 work. SREB, the Southern Regional Education Board, was the first of the compacts created, and it was actually created in the 40s, really to bring the South up on par with the rest of the nation for its higher ed and K-12 offerings. And it actually does a tremendous amount of work there. It's a huge organization. I think its offices occupy a city block compared to MEC, which has 20 employees. So it's a different entity in that way. New York and New Jersey are 2. There is a way in SARA that you don't have to join a compact and you can participate. You can pay an affiliation fee at one time of $50,000. And that is actually what New York and New Jersey are going to do with NEBI, the New England Higher Education Board. So all of these states should come on board this year. In fact, we do anticipate that by the end of 2016, we'll have 45 states at the least.
Other questions of committee members? Hearing none, thank you very much for being here.
Thank you.
And as the earlier speakers, you too would be available for any
Absolutely.
questions that members
Thank you
might
so
have
much.
at a later time. So next we have from the Distance Learning Board, Joe Oyama Miller, is that correct? From the Education Approval Board, and speaking for information only, and Jessica Sabin from the Educational Approval Board for speaking for information only. Welcome.
Welcome. Thank you.
Thank you.
Good morning, Chairman, Madam Chair, and members of the committee. My name is Joe Oyama Miller, and I'm the Vice Chair for the State's Educational Approval Board, better known as the EAB. I was appointed in 2005 and have served under several administrations. I also served as a trustee for the Madison Area Technical College for over 8 years. In the spirit of full disclosure, I want to submit that I'm also the wife of Senator Mark Miller. Before I give my testimony, I would like to have a few questions clarified by the EAB Policy and Program Advisor and Analyst.
Good morning. I wanted to make it very clear, based on the language of this bill, that while EAB regulations and protections would remain intact for Wisconsin-based programs that do not include any online programs, there would be no EAB authority whatsoever to assist students with any online programs or out-of-state online institutions.
So, and we'll be happy to answer any questions after the presentation of the testimony. The EAB is an independent state agency responsible for protecting Wisconsin students by regulating for-profit and certain nonprofit post-secondary education schools, colleges, and universities. Its oversight, however, does not include the university and technical college systems, nor does it include nonprofit institutions incorporated in the state prior to 1992, such as Marquette, Lakeland, Cardinal Stritch, and others that are also members of the Wisconsin Association of Independent Colleges and Universities. Despite the many reservations, this effort is moving forward, and I want to outline the concerns for consideration and also explain possible unintended consequences. The bills considered today create a new board that allows Wisconsin to join the State Authorization Reciprocity Agreement called SARA, a clear effort to limit the amount of state regulation institutions offer on online programs. SARA fundamentally alters how distance education is relegated to Wisconsin in crucial protection for students enrolled in online, out-of-state programs. Currently, EAB oversees 265 active institutions that enroll more than 40,000 students, primarily adult, in over 2,700 degrees and non-degree programs. 119 of these institutions have an online or distance learning program basis and enroll more than 17,000 students. For the past 3 years, our data collection has showed that of all those enrolled in online programs, 55% have dropped at their educational career programs from these online programs. 102 are out of state and are entirely online. 12 operate both online and on ground and are based in Wisconsin. Under this bill, the EAB, as Jessica mentioned, would lose its authority over those online programs. By joining SARA, Wisconsin would be delegating its authority to oversee online, out-of-state institutions to other states and other non-governmental entities that lack, at the moment, statutory power and have no legal enforcement capability, which reduces the ability of these states to protect these residents. I don't believe it's in the best interest of Wisconsin citizens to remove this consumer protection and delegate this authority. SARA may be a good deal for the majority of states with few or any consumer protection for students. However, the evidence it shows that SARA is a bad deal for forward-looking, good government states like Wisconsin, with a long history of protecting student interest and ensuring that large, for-profit, out-of-state institutions operate on a level playing field with those Wisconsin-based online, on-ground institutions. Concerns that SARA will erode the state oversight and fundamentally alter the state's consumer protection of students enrolled in these online programs. In the rapidly evolving online environment of higher education, it is critical that every effort that reduces the oversight of distance education is thoroughly vetted and understood. State higher educational regulators have taken considerable effort to examine and fully understand the implication of SARA on the state's ability to protect consumers. The National Association of State Administrators and Supervisors of Private Schools wrote to the SARA founders in May of 2013 to express their own concerns. The group stated, quote, SARA raises a number of important questions about the state's ability to protect consumers, perform quality program reviews, collect student outcome data, and hold the institutions accountable for their malfeasance, end of quote. The bill states that online program at institutions based in Wisconsin will no longer be under the EAB oversight and would be authorized by the new board, the DLAB. EAB would also lose oversight of all the online out-of-state schools enrolled in Wisconsin, enrolling in Wisconsin students and registered and certified by the EAB. Those schools will then be subject to other states' regulatory structures, of which I may state that many states have ineffective or even no real regulatory oversights. Wisconsin oversees distance learning and measures the success of its online students. SARA stands to undermine and perhaps even eliminate some of the important consumer protection for students. By joining SARA, consumer protection functions will be delegated solely to the state in which an institution is located, which may be minimal or ineffective protection in place. At a time when we are inundated reports from the U.S. Department of Education, consumer protection organizations, and other states that provide evidence of the poor performance of for-profit online institutions and calls for tighter regulations of this sector, it is now concerning that efforts are being made to loosen them in our own state. EAB has a history of successes resolving student complaints and responding to catastrophic events, such as unplanned school closures or serious allegation. The EAB has a strong reputation nationally for its ability to protect its students. Under SARA, students at out-of-state online institutions won't have the same consumer protection and student complaint resolutions currently provided by the EAB. Students will have to work with each state in which institutions are located. You talked about the institutions having to work with each state. Now you're asking an individual to work with each state's consumer protection agencies. The vast majority will have few consumer protections in place. Unequal protection is one of the concerns. Wisconsin resident could receive different protections. A student attending the University of Wisconsin in Milwaukee would be able to work with the EAB complaints because it isn't
Phoenix.
The University of Phoenix in Milwaukee would be able to work with the EAB over complaints, but a Wisconsin student is enrolled but if a Wisconsin student is enrolled in an online program, it must go to the state of Arizona. SARA doesn't stop students from working with their state SARA agencies, but resolutions are determined by the individual's home state agencies. With the number of catastrophic school closings that have occurred in the last several years, the EAB's ability to protect students is even more crucial than ever. Schools have closed their doors in a matter of days with little or no notice. In the Anthem College closure, which was in 2014, as Representative Hesselbein mentioned, the EAB acted quickly and organized options for all of the students. Other states sought guidance from these Wisconsin actions. Anthem College was a large for-profit company that wasn't based in Wisconsin. Under SARA, the EAB wouldn't have had the authority to assist these students in their own state, and also the students in all SARA member states in the country as well. The EAB is concerned over the ability of a single state SARA agency to resolve the onslaught of programs that result from catastrophic structures. Student outcomes are relevant to SARA. Under SARA, the EAB will now lose its oversight of the institutions identified in EAB's annual data analysis as most in need of oversight due to poor student outcomes. Wisconsin students enrolled in online programs at out-of-state institutions are desperately in need of consumer protection. Analysis finds for-profit, online, out-of-state institutions have the worst student outcomes, with more than half of the students dropping out. These are precisely the institutions that benefit from this reduced oversight. Institutions aren't required to report student outcome data under SARA, so students enrolled in these programs wouldn't have protection regarding the high student dropouts. EAB data collection is unique in the level of the detail it has specific to Wisconsin students. The federal data reporting requirements are limited to schools participating in the Title IV federal AIDS programs and excludes smaller schools operating in Wisconsin that don't participate in Title IV as well. Schools that report under these rules are only required to provide measures on first-time, full-time students. Most of the students attending EAB-approved institutions don't fall in this first-time, full-time category. The majority of our students are non-traditional, working adults facing economic and financial challenges, and they need the EAB consumer protection. In many instances, the EAB is the only entity examining all student outcomes for this population. Under SARA, student outcomes will not be collected to the degree that EAB collects currently. It is likely that online for-profit institutions outside of Wisconsin with consistently poor outcomes will not be held accountable for these results. SARA is based on the general misunderstanding of what is required of institutions for state approval and the impact that SARA will have on student protection. Proponents of SARA states that state approval in all states in which they choose to operate is a cumbersome and costly process. However, most states exempt public institutions, like the University of Wisconsin, from state authorization for distance learning. Among those that do require something of public institutions, some states require nothing more than a completed form. Only a handful of states requiring approval of public institutions, and some of those approve entire systems that rather than requiring a separate approval of each individual situation. For example, Minnesota could approve the entire UW system as a single unit of distance learning, as opposed to requiring each of their campuses to be approved separately. Similarly, all Wisconsin Technical College could be approved in one application. A more thorough examination may still be necessary to ensure that all stakeholders understand these nuances and complexities behind the state authorization of higher education. While proponents claim it reduces the burden and costs associated with approving an institution in multiple states, there is no evidence that SARA actually reduces institutional costs, since a comprehensive fiscal analysis of SARA has never been conducted, and the justification for SARA continues to be based on conjecture. 119 EAB-approved institutions with distance learning programs in our state reported $150.5 million in tuition revenues from Wisconsin students in the last year, and for which institutions paid to the EAB less than 0.2% of that revenue. How cost prohibitive. In conclusion, I would like to say SARA benefits large, out-of-state, non-for-profit institutions offering an increasing array of online programs despite their poor outcomes. At best, SARA is going to be a disservice to Wisconsin online students who won't have consumer protection that enable complaints to be investigated, resolved fairly and quickly. It is not in the interest of Wisconsin residents for our state to delegate its authority to oversee online programs to other states and non-governmental entities. If Wisconsin becomes a SARA state, we will be swapping out a highly effective system of consumer protection and regulation, offering for a minimalist, barely existent system whose operation has yet to be fully defined, and about which education administrators are already asking questions and identifying problems. Wisconsin adoption of SARA is not in the interest of Wisconsin residents or Wisconsin-based institutions. I hope the committee will take into consideration the many real concerns and unknowns about how SARA will be implemented as they move forward with this legislation, and I encourage them to entertain alternative policies that will put Wisconsin first. Further examination of these impacts on this policy needs to be done based on evidence-based policy. It may be in Wisconsin's best interest for the EAB to continue providing consumer protection to those students in its distant learning institutions that it currently oversees, while allowing the public entities and private nonprofit institutions to participate in SARA. Those institutional sectors of higher education have student protections already in place that are not inherently available for students at private for-profit colleges. The EAB provides these protections to these Wisconsin residents. Thank you again for the opportunity to testify, and I'd be happy to answer any questions. I also would encourage is that recently other states have been looking, and those who have been in SARA have been looking, and reports have been coming out. In August of 2015, the Portland Tribune looked at what its state of Oregon was doing because it had a lot of questions. They began to look at its portal for student complaints, particularly for for-profit students, and found that it was not only cumbersome but difficult. It was difficult to understand that you can only have one option to do it, was to download a 4-page form, complete the form, mail it back in to the authorizing state agency to review. So students were saying, first, we didn't even know where the portal was. The state of Oregon had a very difficult time setting that out. Secondly, how to manipulate it and get to it and to be able to do those things. So be sure that you begin and have your staff look at some of the research and the issues that are coming out of those SARA states that have already been adopted and what they're doing for some of those issues that each of you just asked today. The other question I want to really make sure is that people understand regarding the responsibilities and regulations of EAB is the EAB is also the reciprocal, the repository of all student transcripts and information. I would venture that under the new SARA law, that the DLAG may not choose to become that repository. So what does that mean? That means if you entered Anthem College before it closed, and you had enough courses that you wanted to transfer, you could call the EAB and say, I was a graduate, or I went to Anthem College in 2010. Can you retrieve my transcript for me so that I could bring it to the tech college, I could bring it to the university? At this moment, the EAB can do this. It has boxes and boxes. We're really trying to figure out how to become more cost efficient regarding these things. But that is a critical piece. I know the University of Wisconsin has my transcript. I graduated in 1967, and I recently had to have my transcript. I just went down to the university, paid my money, and was able to get my full university transcript showing the degrees to what we do. I want to ensure that every online distance person taking a class or receiving a degree will have it in the future. I know that all the other gentlemen and women who were here before, their institutions have that. Those students who who are registered and have gone through the University of Wisconsin, the Tech system, the WICU systems, they're responsible already not only to the State Higher Education Board, the federal government, because they use Title IX and Title IV funds, but they also have their own Board of Regents, the Board of Trustees that will continue to protect their students. The EAB, under the current law, will say it will lose its ability to oversee and regulate their online students as it stands now in this bill. Thank you.
Thank you, ladies, for your testimony. We'll entertain a few questions then. Actually, my first question would be, as I understand it, you registered as testifying for information only.
Yes.
So I'm a little bit confused because it seems like you have a pretty strong position here. Does your board support or oppose this bill?
Our board is probably very supportive. We have not taken a vote on it, on what we do. Our board has continually asked and to be a part of the discussion. We have a board member who is also a member of the regional MEC. And so we have been involved, but we really want, one of our concerns, the board's concern, is that under the current bill, that the EAB will lose its ability to oversee those for-profit entities, of which they are a large percentage of the students coming up to us.
Based on discussions that we've had with our board chair, he was very adamant that we simply express the reservations that we have.
Yes.
Okay. Representative Quinn.
Hi, thank you for your testimony. It was very informative. My question kind of touches off of Representative Murphy's. In your conclusion, you state SARA is a gift to large out-of-state for-profit institutions offering an increasing array of online programs despite poor outcomes. SARA is at best a disservice to Wisconsin students. Do you not believe there's anything positive whatsoever with this piece of legislation?
Sure.
Well, I'd like to state that we actually think SARA is a really good initiative for states that don't have the protections in place that we have here. Wisconsin has always been ahead of the game as far as ensuring that students have proper protections in place and are able to adequately resolve any issues that may arise. I think that prior to the federal program integrity rules, the vast majority of states did not regulate distance education. So for states such as Idaho that didn't have anything, I think SARA is very effective because it replaces something that didn't exist. However, specific to Wisconsin, I think that this will remove many of the protections that we have in place to respond to many of the issues that have been arising recently. In regards to the public institutions such as the UW system and the Wisconsin Technical College system, I think, and as well as the WACU schools, I think that this may be beneficial to them as well. However, as Ms. Miller expressed earlier, those institutions have several protections in place that the EAB works to provide students that are attending these online for-profit institutions. So that is why we don't believe it's in the best interest of the Wisconsin students at those institutions.
Perfect. And if I may, Mr. Chair, one more follow-up question. Are you aware of any statistics, and I know this is fairly new, in the other 36 states, are there statistics that show, even in states that formerly had protections that may have weakened under this, has there been a rise in complaints or, in fact, a lack of resolution for some of those complaints? Are you aware of that increasing for states under SARA?
Not explicitly. However, I recently was reviewing their website and they posted a fall report, and it didn't seem that there were any complaints that had been reported thus far, but anybody more familiar with the initiative could correct that.
One of the things that the Portland Tribune article brought out was that in other states who have adopted SARA, they've also been tweaking their legislation. consistently, which is good. I mean, it's not to say that if the legislation is adopted as it stands now, it doesn't protect the for-profit students taking online. But if they were able to put in safeguards or a system where all students are protected equally, I mean, our earlier presenters talked about wanting equal protection for all students. At this point, as the bill states, I don't believe, and I think my colleagues on the board will say that the for-profit students are equally protected, that when you have to go back to your home state institution to complain, it's difficult. It's even difficult for people to know within the state how to come to the EAB. They're hesitant in many instances, but they come. We have school consultants that also work with the school looking at those issues. So the first resolve for most EAB complaints is to work with those institutions, because we have educational consultants that want to make those individual schools regulate better. So we find serious allegations, find defaults, find problems, we begin to look at that. And part of it is in the initial process of looking at what are the programs going to be offered, what are the quality of those programs. And that is a concern, because as it stands now, an online for-profit school would register, pay a subscription or a membership fee, but their program itself is not going to be evaluated, you know. And I think, again, putting in more safeguards, if you want, to do that into the DLAB board, but then the DLAB board becomes a different microcosm of the EAB, you know. So what I'm saying is that SARA in its entirety shouldn't be thrown out the window, but I think more vetting, more analysis, more fiscal review is in the best interest for Wisconsin residents before you as a body of legislators take this under real consideration.
Sure.
And one of the things that I've been noticing in some of the states and reading the background material just recently is more and more states are receiving complaints through the DOJ, their DOJ offices. Sure. All right, so so you might save money on one area, but if DOJ has to go and fight a school like Anthem or Corinthian, where is the cost savings? So again, you have to look at all of those unintended consequences to be able to do it. California and Governor Brown is looking at some things to tighten up what their SARA reciprocal pact might be doing as well.
Perfect, thank you. Just one more quick one, if I may. Representative Murphy asked where your board is generally on this, and you said generally supportive. I guess I didn't hear any comment supportive in your testimony, and I know it's your job to come and express the reservations as well. Could you touch on some of the instances or ideas that they are supportive, some of your board members, and why they are supportive in certain instances of SARA?
One of the issues that comes up to our board is the serious allegations in terms of how education is being brought forward, or the degree that, and most recently, the University of Phoenix in the Fox Valley area, a student actually went to the television stations and complained that all of her coursework that she was taking at the University of Phoenix for her human services, it appeared that they would be transferable, it would appear that it would have valid, and then when she wanted to use those credits to transfer, you know, they were held to question. And so we were brought in, the EAB was brought in to evaluate it, and it started with one complaint. And as the school consultant began to look at the complaint, 10 or 12 complaints came up regarding this particular program.
I guess I'll try to, my question a little more specifically. You mentioned some of your board members are supportive, correct?
Yes.
Of this. Could you touch on some of the reasons why they are supportive?
Well, they're supportive in the sense that they believe that there ought to be, that we were included in the initial portal, that the EAB stands at the table for DLAB. So that was really good. Is that we've been asking our executive director and the member who's on MECA to be very specific is how the rules and the oversight will continue. And so we felt that we were still in a learning process of getting information to feel more comfortable that if the EAB lost oversight, how would it, and some of those answers have come, others are still, I think, work in progress.
Senator Harsdorf.
Thank you. Well, I want to commend and thank you for the work that you do at EAB. I think you are important. Obviously, we've had some discussions and proposed changes to the EAB earlier this year, and I want to acknowledge publicly the important work that you do.
Thank you.
So obviously, as the author of the bill, I'm a little concerned with your testimony, though. But you have been an important voice, and you have been included in the discussions throughout this entire process. And we appreciate that participation and continued involvement in this. I think when one of the things that is required under SARA is making sure that students have a complaint process. And so while it does propose a change for EAB for particular institutions, the bill does recognize the importance of maintaining a good complaint process for students. And I wanted to recognize that. I think one of the things that concerns me is if we don't do this. And so if we don't do this, it is going to be a huge, not only administrative burden, but it's going to be costly to our institutions. Or it is going to close out opportunities for students. Some time back while we were discussing this, I got a call from a constituent who wanted to take a course. It was a very rare course, a program area, course offering in another state. And the door was literally closed for them to take that course because that state was unwilling to pay the costs to cover that. Because that institution would have to get approval from our state since a student was a resident of Wisconsin. So that closed the door to a Wisconsin resident on being able to take that course offering. And so there are implications for students as well. Did you need clarification on that?
Thank you. Yes.
Okay. So the question I have for you is, do you either have, and obviously this legislation has to be drafted carefully so that it does meet SARA's requirements, but do you have suggested changes or address my question as far as if we do not pass this enabling legislation and move forward, the impact is going to be additional costs and administrative burden, and as was highlighted earlier in earlier testimony, it would enable the feds to oversee our curriculum and program, the design of our programming within our campuses.
So I'd like to speak directly to that particular instance with your constituent because I am very familiar with that. I spoke with her. She wanted to attend a program specific to a master's in Holocaust studies in Pennsylvania. We worked with that institution and this particular student, and we had expressed several times to that institution. Pennsylvania is also not a member of any compact presently, and would be one of those institutions, I believe that was mentioned earlier, that would elect with an additional membership fee to participate. But we have a de minimis test for these schools that resolve issues such as this one. We were very clear with the institution that we were not going to require it to seek our approval because it was one student. This is one program that they could attend in the country, the only one. So we issued a letter to that institution. We made sure that student was able to continue her studies. I think that the complaint process SARA will have is not going to cover all of the, or allow for the resolutions that EAB is currently able to do. At present, we're able to adequately address the issues of Wisconsin residents under SARA, we believe that shifting out that responsibility to, as far as online institutions go, the state portal agency in which that institution is located is delegating out, because that state's laws are what will be applied and what that institution is able to do for that student. The EAB is able to develop relationships with the institution it oversees. As Ms. Oyama Miller was mentioning, the University of Phoenix had a issue with fraud and misrepresentation for its human services programs. Students were told that they would be able to continue studies and become licensed social workers. However, that was not accurate information. But we were able to work with the University of Phoenix. We had that relationship in place, and we were able to negotiate satisfactory resolutions for those students. As far as the administrative costs that may arise in the future, I feel like I would need a bit of clarification as to what you might be referring to.
The requirement that under the federal regulations, an institution would need to get approval from the resident state of any student that they're providing online education to, which would mean in excess of 50.
So a review of information available on the State Higher Education Executive Officers Board lists out each state's requirements, and according to the federal language, an institution does have to comply with that state's laws in which it would like to operate. If a state's law exempts public institutions, then that institution meets those requirements and doesn't have to do it. It is true that they will have to do a little bit of research to find out what exactly those are, but I want to maybe say 12 or fewer states in this country require public institutions to be authorized, meaning the others would exempt those institutions.
And that is allowed under these are federal regulations.
Yes.
So under federal
The
regulations.
federal language states that the institution must meet the state in which it would like to operate those laws. The majority of United States laws state specifically that public institutions are exempt from their oversight.
So then institutions would have to monitor that on an ongoing basis. It could change at any time what each state does. So, I mean, this is intended to simplify, simply because this should not be, we want to streamline the process. As online courses grow in popularity, it will still be a challenge, as you indicated, that institutions would need to monitor each state and potential changes that they would enact as well.
That is correct. However, I believe the burden associated with that may be overstated, because I am simply able to do such an activity in one day on one website, and that may require follow-up with a few states. And yes, it is correct that that institution would be in its best interest to actually contact that state to clarify, receive exemption forms, and there is a cost associated with that. That's correct. But I question how burdensome that may be, and if it really indicates the administrative costs that have been indicated.
Do you have specific changes that you believe would be appropriate to address your concern? Because this does put in place, required under SARA is the student complaint process. And so that ensures that that is in place, regardless of what state. So do you have specific changes that you believe would make you more comfortable that would still meet the SARA requirements?
Our main concern with the complaint process as it stands is, yes, there's a process in place. Yeah. However, the state outside of Wisconsin, those laws are what apply to complaint resolution. And yes, Wisconsin SARA State would be able to assist in that, but according to the SARA policies, the language indicates that the ultimate complaint resolution lies with the other SARA state entity. And as far as revisions that might be made, I don't have any explicitly offhand, but
We would
that's,
defer to our executive and have further discussion whether would the complaint process be the similar or the same as what currently occurs under the EAB oversight and regulations, or can they be streamlined to make it better, so that under SARA law, that the for-profit online distance learning student would be well protected in case that home state had little or no protection for that student. How would it go to a default? One of the things that I think that might give you, the legislative committees, an understanding of the magnitude and the complexity of responsibility and student protection is by looking at what the board members do of the activity sheets. It is important that students know when an organization changes their ownership, right? Or if it changes a location, or if it changes that they are now adding a variety of different programs and degrees. All of these things are then first vetted by the educational consultants as they get information from that individual for proprietary school to say, I want to add a master's degree in criminology online. The educational consultant will say, what does that mean? Who teaches those classes? What is the validity of getting that degree from that particular institution online that doesn't lead to a job outcome or to a better understanding and allow you to transfer on to another institution, whether it be our tech colleges, our independent colleges, or our university systems. These are the kinds of activities and protections and review that the EAB and its consultants do. And in the same way, when they receive a complaint, they do thorough investigation to be able to do it. Should this school be fined? Should the students be rebated? Should the students be protective? Under EAB oversight, all schools pay a surety bond. All schools put into a student protection fund, right? That they have, so taxpayer dollars are not used to rescue or help out students of the Anthem closure. They were able to use the Student Protection Fund, the surety bonds, to ensure that every student that was now denied an education or completion of an education through Anthem was going to be made whole, either through monetary resettlement or through a teach-out. And in addition, much of the equipment could be transferred back and forth to other institutions that could use it or in place of something. So it's an ongoing dialogue that, as I perceive under the SARA law, without knowing what those protection provisions would be that DLAB would create, it's difficult to give up, this protection that EAB gives to its students. But it was eye-opening for me when I first came on the board to look at the number of students, the breadth of programs that are offered. And I was excited to know that the state of Wisconsin had one of the best agencies regulating for proprietary schools. We are the benchmark for the nation. When we do a school closure settlement, and other students are also from other states, they look to us. And I would hate to give this up for our students, but also for our agency's reputation and for the state. It's one of the things we shine in, is student protection. Not only at our public institutions and our private institutions under WIGU, but for our proprietary schools. And as one of the other presenters said, it's not saying that all proprietary schools are bad. We have wonderful ones. And those that are wonderful are appreciative of the EAB to monitor and oversee the schools that could easily slip under and take advantage of our students.
I believe that part of this whole conversation simply indicates that perhaps further research and additional alternatives are analyzed to ensure that Wisconsin students have all of those protections in place. Because the EAB is able to handle complaints from Wisconsin students, it's a more efficient, smaller operation that we have control of as a state. However, under SARA, that's delegated out to these other states. So the state of Arizona, for example, unfortunately, University of Phoenix, the one we pick on because it has a presence everywhere, but were that institution to close, the Arizona state would be responsible, the portal agency, for handling the vast majority of the country's complaints. Granted, yes, the Wisconsin State Portal Agency would have a hand in that, but ultimate responsibility falls to the Arizona State Portal.
It would seem to me that the EAB will be here for us to protect our students in the state of Wisconsin that are going to school here in the state of Wisconsin.
Correct.
Correct.
The EAB will continue its on-ground, meaning campus-driven programs for the state. But if a student is taking an online program from University of Phoenix, from Rasmussen, from Globe University, we don't have the control of that student taking the class online in Wisconsin. If it goes back to that home state portal. In this moment, it
Sure.
could be Minnesota, Iowa, Mississippi, it could be wherever the program is.
So my student is going to a Wisconsin university. They're protected by the EAB. Right now, if they went to a institution in Arizona, they would not be protected by the EAB. And now they won't be protected by Wisconsin if they happen to be in Wisconsin and are taking a course from a institution in Arizona through the internet.
Actually, assuming that that student maintains residence in Wisconsin and it is an EAB-approved online institution, we would.
At the present time, we would.
At the present, okay.
Yes.
Under this bill, the online learning, though, then would be transferred, the regulation of that to.
Yes, correct. We have approximately 17,000 students in Wisconsin enrolled in online institutions. 102 of those institutions are completely out of state, entirely online. So I would estimate upwards of 80% of that 17,000 are residing in Wisconsin and attending out-of-state online institutions. We currently are able to provide the student protections we have. Under SARA, we would not.
Senator Hurst?
Yeah, just to clarify though, those students would still have consumer protections under SARA. So I don't want to mislead
Right.
anyone
Mhm.
here to say
Yes.
that all of a sudden these students would no longer have student protections. There will be a change, but that is something that is a critical component under SARA. And I don't want to run into an ongoing debate, okay?
Well,
Because we need to move on. But the point is, there will still be student protections required under SARA.
But it may be very different, and it may be minimal compared to what they are getting currently as the system stands under the EAB.
Okay, thanks.
Representative Lux.
Thank you. I've been listening to this, and I think perhaps much of my question has been answered, but let's assume for the record, in Wisconsin, we have something called Consumer False Advertising Statute, Section 100.18, which protects Wisconsin residents in the event that they've been lured into some contractual relationship through false advertising. Let's assume for the record, I don't know where my staff guy is, Bob, but Bob is a really, let's just take Bob for an example. Let's assume that he's taking a dental hygiene course from an Idaho college. and let's assume he finishes this and takes out student loans in order to take this, incurs a lot of debt, and this is an Idaho-based online university. And let's assume further that Idaho doesn't have a consumer product statute like 100.18 is. So Bob gets up to the time to take the board exams, and it turns out he doesn't qualify for the boards because some of the underlying classes from the Idaho institution don't work for the qualification. And I don't know I assume they have boards that they take for dental high. What this proposed legislation would do would force Bob to go to Idaho if he's going to bring a lawsuit or if he's going to somehow get compensation for the student, for the situation. Am I understanding that correctly?
Yes.
That student would, under SARA, work with the Idaho SARA portal agency.
But if it was the way things are right now, he would have recourse here in Wisconsin.
Yes, the EAB would personally handle such issues directly with that institution.
Okay. And if I can ask a follow-up, I do, and maybe this is for Ledge Council, but I'm unfamiliar. There's a lot of things about this online thing that, I mean, number one, how do we know the person that's sitting at the screen is actually the person that's supposed to, but that's probably not, you know. Could have saved a lot of time with law school if we just have somebody, but, do a lot of these institutions, I'm unfamiliar with how somebody signs up for one of these online classes, but do they have arbitration agreements in them? Do you know? Is that something? Because sometimes people give away their rights to in-state recourse when they're signing up. They may agree to arbitration. Going back to my Idaho hypothetical, you may be agreeing when you sign up with the class to arbitrate in Idaho if you have a problem. I don't know. Do these have arbitration agreements typically?
I do not know. Mary, do you know?
I can speak a bit to that. I know that, please don't quote me on this, I believe that it is not technically legal for us to stop any institution from requiring arbitration contracts of their students. However, if an institution does have arbitration in place in the student moment, that does not preclude the state of, like, the Educational Approval Board from assisting the student. However,
So you would supersede that then?
we would still be doing what we can. We wouldn't be doing anything legally, but we would be working with that school to continue to resolve that complaint.
Okay, thank you.
Representative Purcell.
Thank you. I guess my question might be for the bill's authors in terms of what is possible. What I'm hearing is a concern that students might lose access to transcripts as one very important piece of information I think we got, that EAB serves as a portal for that, so that perhaps if we're going to have a really strong bill, that we would and that we would address the issue of the portability of or transferability of credits as well, so that our students aren't just playing out in terms of the money that they've spent. So I have a two-part question here. One is, can we have some sort of linkage where we go beyond SARA to have these protections in our state, despite the fact that this is not part of the national model? So is there a way to facilitate that and also put that in the bill as something that we in Wisconsin do want to do? And then the other thing is, we keep talking about the fact that SARA is going to have a complaint process, but what I'm hearing is the difference between our state and others. One of the big differences is not that there's a complaint process, but that there is resolution help. So consequently, I mean, a complaint process is only as good as there's resolution. And so I'm wondering how we could continue to have that interact as part of keeping our program as strong as it is now, yet being able to join the national effort.
I'd like to answer one of those questions, is that Maryland in 2011 revamped its original SARA agreements that they had with their regional area and strengthening the rules regarding deceptive practices and recruiting for a for-profit student protection by requiring them to have a student protection fee that is paid into by the participating members of SARA, so that if money had to be paid out, it was also paid in by those institutions to protect their students. And so it isn't to say that what you have now is the end all. It may begin, as Representative Brousseau said, is your beginning piece to continue to look at it, look at other organizations and compacts and see where the biggest problems have been and rewrite some of the best practices. One of the reasons EAB, Wisconsin EAB, is as good as it is we look to all the states continuously for the best practices. And we work with our federal program advisors and mentors to say, what is it that you want that we can provide for you in the best way to protect our students and hopefully in the most efficient and cost-effective way. And I think this is someplace that I hope Wisconsin's SARA program would be dedicated to, is that if we're going to join SARA, let's be the best. Let's be the benchmark. Let's be what others will then follow and not just follow.
Representative Brousseau?
Yeah, I guess that's not exactly where I was going with this.
I'm sorry.
Well, no, that's fine, and I understand. Let's assume that, I think what you're saying is see what changes we can get at the level of SARA on some of these things. But let's assume this bill is going forward, which I believe it is. My question was, can we make sure that we, in what we do here, link SARA to the EAB in some way that we address issues of the student transcripts and portability or transferability, whatever. I don't think that we can necessarily change policies of SARA immediately. So joining it would, I hope I'm making sense. Do you see where I'm going with this? It's just making sure that we keep some of our stronger protections that we don't believe exist maybe under SARA. Is that possible? Addressing the student transcripts, addressing transferability of credits, et cetera. Is there a way for us to link to current policies?
So what are you suggesting under transfer? Because this does not. What do you want under transferability of credits? Because I believe, isn't that an institutional determination?
Yes.
I would think that would be an institutional determination of what is going to be accepted in transferability. SARA does not get into that.
But it was my understanding from the testimony that EAB does play a role in helping students if they discover after the fact that something they thought was transferable is not, or whatever. I don't know
So
where
you're
the
talking about
slippage.
student
the resolution process.
Yeah,
If there's a
I
student
think what I'm hearing, the bottom line is that our EAB works not just as a complaint process, but as a resolution process. And we may be losing that under SARA, and I'm asking, is there a way for us to continue that resolution process as part of what we offer in our state as a protection?
Okay, so under the SARA, you first, if you have a student complaint, you first go to the institution. And if it's not resolved by the institution, then you go to the portal entity. And
But what I'm saying is there, well, maybe we can talk about it afterwards, but what we're hearing is the portal entity is not necessarily going to offer the protections we do now. So let's say you're turned down by the institution or they don't resolve it, you go to the portal and you don't have the resolution that you would get now in terms of assistance with that from EAB. Can we still offer that type of resolution process as a backup? Or I guess I'd like us to talk about how we don't lose the protections that we currently have just because we joined SARA. That we find a way to address some of those.
So keep in mind, EAB will have a representative, they are representative on the DLAB board.
Will that mean, though, that that EAB still will have the budget and staff to provide the consulting services and the assistance, the resolution process that they do now?
One of the responsibilities of the portal entity is to be responsible for that resolution process. So if your suggestion is to provide, to direct EAB to be that individual entity, I do not believe that will meet the requirements. One of the things that as was said earlier in the testimony, every state is a little bit different. One of the challenges Wisconsin has had is we don't have a natural entity in existing that would serve as that portal entity, unlike some states who might have a higher education board already in place that could serve. We didn't have that natural entity that would represent the different systems and institutions within our state, and that's why we've created this. But we can get a further clarification from MEC on your specific questions.
I would appreciate learning what the board can do. For instance, if a student finds out that they can't get their transcripts, it sounds to me like that's something that SARA has to address in advance, that there is some repository for student transcripts. I would be horrified if I took a degree program and there was no access to any information about the coursework that I took, and I'm just out the money and tough luck. So it sounds to me like that is something that it has to be looked at. And if there isn't a repository now, I'm hoping that what EAB does in terms of the existing repository stays in existence to help out at least students in our own state.
We will get clarification for you.
Thank you.
Representative Broadcast.
Great, thank you, and thank you for the testimony. Just a couple questions. How many complaints do you get in a 12-month period?
I do not have that specific figure offhand, but I would estimate about 50. However, one of our main talking points that we are very proud of is that we like to address issues before they rise to that level.
Okay, so out of the 50, or approximately whatever the number is that, how many different individuals is that?
50.
Okay, so it's not,
It's not one student making several complaints.
Okay, no, that's fair. And then out of those 50, how many of those complaints do you find are valid approximately?
According to our executive director in an interview that he gave with the Portland Tribune, He said the Wisconsin board gets about 50 complaints a year for students at for-profits. About half warrant a formal investigation, and about half of those complaints the board finds in favor of the students. And it can go, I've been on reviews regarding complaints where we've had to bring in DOJ to look whether it warrants school closures, school forfeitures, using student protection funds, and a whole variety of things. Some of them, as we said, is before it
Sure.
becomes.
Okay, that's fine. How many schools have closed that you represent in the last 12 months?
At least
We had
3, and we have one more closing right now.
yes,
Yeah.
but
Okay, and out of the dropout rate, you quote 55% of online programs drop out. Do you know where they go?
well, that does not include transfer students. That's a separate metric.
Okay, so
those are
okay,
solid
okay.
drops.
Those are okay. That's good. Maybe back to the online. Out of the 112, let's see, or the 119 that have an online presence, how many of those institutions have you received complaints about?
I do not have that information at hand, so I can't.
Just
give
a
you an accurate
suggestion, when you put
answer.
data into a document, you might want to have that backup information at a testimony. Thank you.
Thank you.
Okay, Representative Billings?
Thank you, and my question might be for the author or Ledge Council. I'm wondering about the ability to tweak SARA after we enter into the agreement. So I see that in the legislation, a yearly report comes to the governor and to the chief clerks of each house, and it's distributed to legislators. How is that usually done? I wonder if you could remind me.
As far as what?
How the report that will be generated, I think it's the first one is January 30th of 2017, and then the yearly report that comes after.
Is that the list of institutions?
I'm just trying to see how it's described. It's on the page 10 of the bill. Yeah, I guess that's for exempt institutions. How will we learn of the results of SARA? How can we be checking in to make sure that we feel like our students are protected and find out about complaints? And then, that's my question number one. And number two is it possible for us to tweak our agreement with SARA as we go along?
Actually, what we've talked about as chairs is, given the questions that have been raised, and since Mac is here and Jenny Parks is very familiar with this, we're going to have her come up and answer those questions when we're done with questioning.
Thank you.
Okay. And Senator Brealey, do you want to ask your question now, or wait till Jenny comes up? Okay. Any other questions for the EAB? Anyway, thank you very much for being here. Thanks for your testimony. And before we, I'm not sure if we should go on with the testimony or bring Jenny up right away. You want to come back up? We don't normally do this, but given the fact that these are important questions and we might be able to get quick clarification.
Thank you very much. I feel special that you're doing something unusual. So there were a lot of questions and a lot of points that came up as the ladies from EAB presented their perspective, and I tried to write them all down, and I can go through my notes, but it would be easier for me if you went ahead and just re-asked a question on which you did not have any clarification or which you had some lingering concerns.
I would like to ask a question. You know, one of the things during this presentation is sort of the insinuation somehow that other states don't have any protections. And, you know, whereas, you know, we like to think that in Wisconsin here we do it better than everyone else. But, you know, I really like to know what kind of issues that we might have with other states. And really, you know, it's not as if this isn't we're not reinventing the wheel here. This has been done by 36 states. So,
Right.
What kind of complaint process have we had going on, and,
Sure.
where's that at? So,
Well, I think you are spot on, Mr. Chairman, that this is an issue of trusting that other states can run their higher ed entity competently. I mean, it is a reciprocal agreement. We trust that they can authorize drivers. We trust that they can marry people, and we'll observe that. This is one of the things where we have to trust that if they've gone to the trouble to look into this, to pass legislation, to create a portal entity, and to join into this initiative, that they will do so in good faith and conscientiously. Because they're not doing it without the eye of the regional compact on them and without the eye of the National Council on them. I can assure you that we don't look at an application that is not ready to go. There has been one state application that was denied, and that was Iowa, and I will let you know I denied it. I'm the one who said, we thought we had a deal, and I'm sorry, but we don't. And they went back and they tweaked it, and Iowa is now a member. I can speak to some of the very specific issues that have come up. Wisconsin's application will not be approved unless there is a provision for DLAB to create teach-out plans. It will not be approved if they do not tell me in that application where transcripts go if an institution closes. And it will not get past me. I mean, obviously, the Regional Steering Committee is the ultimate arbiter and will approve, but it won't get past me if it does not include the plans that DLAB has for how students are made financially whole if in a complaint process or in a precipitous closing situation, they, a teach out or some other remedy is not the right one. Those are all parts of the state application. And beyond that, for the very first time, the institutional applications for SARA participation asks for the chief executive officer of every institution to have those plans and sign off on them as well. And every year we renew it. This is the first time that I can tell you the president of an organization, the chancellor, as we use that terminology in Wisconsin, has to actually know what the teach-out plan is for that institution. A lot of times they don't. It's something that gets rolled in with the accreditation work maybe 10 years ago, et cetera, but the actual chancellor, provost, would never lay hands or eyes on it. So this is something new with SARA. We are saying, guess what? You have to know what the CRAC guidelines are, the Council for Regional Accreditors for Distance Education. You have to know and be willing to sign on the dotted line that you will back up the fact that you have enough tech support 24/7 and that your online students in Mississippi have access to an adequate online library, and so on and so on. There is accountability at the personal and institutional, state, regional, and national level here, where the pressure and the eyes upon every institution in every state is substantial. So I hope that helps you with the whole teach-out plans, transcripts, and refunds question. Those are big deals in SARA, and they continue to be the ones that receive the most scrutiny, I would say.
And I do have to admit, occasionally, I've questioned the quality of driver training in Illinois. But, we get by and we live with it.
Exactly. You're welcome.
Could you also talk about the resolution process and the various steps? Because there is concern that we're losing the
Right, and I do appreciate that, and the ladies are absolutely right. EAB is among those group of elite regulatory and higher ed oversight agencies in the nation. Now we also have one right next door in Minnesota, and we have one right to the south in Iowa. We really do have the bulk of those elite institutions with the platinum standard of consumer protections in our neck of the woods. So it is the standard of care in this part of the world. But DLAB can be as assertive and as forward-looking as it needs to be to assist in the resolution process. There is absolutely nothing that keeps them from doing everything on behalf of Wisconsin students. They would have purview over out-of-state students attending Wisconsin institutions. That's who DLAB would serve. DLAB would serve them. Only out-of-state students attending Wisconsin institutions. EAB would still serve students in, at proprietary institutions on the ground in Wisconsin. And then the portal entities in other states would serve Wisconsin students attending their institutions online. And all of those portal entities have the right, and I would say the motivation, to be very assertive in the resolution process. It's very important to the people who've gone to the trouble to work this out and deal with this, that they do it right. I don't know of one cavalier, flippant person in the SARA universe. And yes, there are some states that for the very first time have to do this well. And they are. They really are. If you've ever dealt with any of the folks from Louisiana, I do remember when I first started doing state authorization work at UW-La Crosse years ago. And I remember calling around trying to find out how you get authorized in Louisiana and how you get, well, first of all, there was South Dakota. And they said, call us back in 6 months and we'll tell you how you get authorized in South Dakota. Because they didn't know. They didn't have a process. And in Louisiana, it was a very strange phone call. It was like, well, you got buildings? Yes, we have buildings. You have teachers with like degrees and stuff? Yeah. Okay, you're good. Now that's how Louisiana was when this started. So the ladies are right. But Louisiana has gone through a tremendously rigorous overhaul of all of its laws since then, and they are tough-nosed. And the people who are in charge of it are, they're formidable. So I would not have any concern about a Wisconsin student attending a SARA institution in Louisiana now, because it is so rigorous and they are so serious. And I would say it's the same in every other state, because this was a very shocking wake-up call for the states that did not have good systems in place. And those that are still struggling to have a good system in place, which, by the way, was mandated by the program integrity rules. The deadline for having all those things in place at the state level was July 1st of 2015. They've come a long way, and in fact are some of the most assertive and aggressive agencies we've seen. So I think we have to trust them.
Thank you. Senator Bewley, did you want additional questions?
Yes, thank you very much. So in order to participate, we have to come up with a portal entity, which in this legislation is called the D-Lab. And I'm sure that SARA has some minimal requirements for what the portal entity would look like. Could you, for example, say, because we know what's on our D-Lab, is it similar in other states that it's this composition?
No, there are only 2 states that have gone with this model. The first one was Arizona, and the second one is Wisconsin. And this is, and there are some differences there, but basically they put together a council of representatives from various stakeholders in their higher ed communities to make sure that those are the people taking a look at SARA institutional applications and the oversight of the export of their online educational services. So no, in most states, I can give you, for example, it is the person who's regulated online education for out of state the whole time. But that tends to be in other states part of a higher ed entity.
A higher ed board. So how many states in SARA don't have higher ed boards currently in existence?
I can tell you the ones in MEC because I'm intimate and familiar with those. Michigan does not. So Michigan had to go with, actually it went with its licensing and regulatory bureau, which actually regulates carnival rides and MMA fighting and things of that nature too. But they are very tight and rigorous. Again, Michigan came on board last fall, and I've been doing all my workshops for my Michigan institutions this fall. And it is an amazingly tough and tight system that they've got set up. So no, there is no higher ed board in Michigan. Those are the only 2 states actually in the MEC region that don't have a board of some sort. Now, it might not be a central board. For example, in Iowa, they don't have one central board over every institution. The Board of Regents has become is kind of the folks we were working with there. So we went with their student aid agency in Iowa. So I guess that's another example. And then in Indiana has a coordinating board. Illinois does not. So Illinois, we've gone with the Board of Regents again.
So, but is there some standard composition that you are looking for? Because let's say there's something, Can you say no? Can you say, no, this isn't good enough? I
No,
don't like
I
the-"
can say, no, this doesn't meet the requirements.
And
This
what are
doesn't-
the requirements?
The requirements is that they have the statutory ability to join the compact, and that they have the statutes and regulations in place to do their work as a portal, meaning that they do have the ability to get the information they need from the institutions, that they do have the ability to carry out complaint resolution, and that they do have the ability to work with us, again, through statute or through regulation. They need to be able to work with NC-SARA and with MAC to resolve any complaints or any issues.
Okay, I have one more follow-up question. Is there anything in the legislation that we have that you know of, or in the agreement of SARA, that would prohibit one portal entity from talking to another portal entity?
No, in fact, it's part of the unified agreement and the policies and standards that it is expected that there will be a lot of communication between portal entities. And in fact, I know if you are in MAC, we have portal agent calls about once a month with my office where we all talk to each other and share concerns, but they've all had conversations with each other all the time. Most of these folks all know each other. They're part of the regulatory community, and those that are going to be new, perhaps the person who would be on that phone call each month with me in Wisconsin would quickly become a part of that team. We also have annual portal agent meetings for across the nation. Again, we just had our first one in December in Denver. And that's one of the big pushes that is on the NC-SARA work plan for this year, is to develop the relationships between portal agencies and develop a common set of best practices, templates, resources that help them do their job and help them do it consistently and at the highest level.
Do they report back to the states? I mean, annually, we, tell Wisconsin EAB would be able to find out, or the portal entity, which of course EAB is on, they would get a statement saying, we handled this or at least, numerically, we handled so many from Wisconsin, so that Wisconsin would know.
Sure. Well, there are two things here. All portal entities have to report on a quarterly basis the complaints they dealt with, how they dealt with them, the resolution type, to NC-SARA, and that is in real time on the NC-SARA website. So that is available for everyone to see. As far as the reporting that DLAB would do back to Wisconsin, it is referred to in the bill, and I would say yes, that in most states, the portal entity is required in the SARA enabling legislation to come back to at least some portion of the state governments, whether it's back to the Board of Regents or back to the Higher Ed Committee, and let them know how things are going. And in the case of Michigan, their bill it sunsets after 2 years, so they renew every 2 years.
I guess what I'm getting at is, would EAB or the DLAB here in Wisconsin be able to find out after a year how many Wisconsin students sent complaints out to other portal entities?
Yes.
Okay, thank you.
Okay, Representative Billings.
Thank you. Thank you. Senator Bewley asked a lot of my questions and did a very nice job of it. So just to make sure I understand, so our DLAB works with other students that contact our state with complaints. They're
Right,
a portal
right.
agency.
Yeah.
And our students, our complaints are spread throughout, but a quarterly report will be on the website, SARA website. And plus an official report goes to, in some states you said Board of Regents or other, do we have an agreement where it would go here in Wisconsin?
It's whatever is outlined here in the bill, however the reporting is enacted here as it is outlined in the bill, or as you choose to enact it.
Pledge Council can answer that. Thank you.
I'm going to answer your question regarding the reports. Initially, the initial agreement is submitted to Joint Finance for passive review. Okay, and if they have issues that they raise with it, then and they decide to have a hearing on it, then the agreement has to be passed by Joint Finance. Then there's also an annual report that I think you were looking for. You'll find it on pages 7 and 8 that is submitted to the legislature on an annual basis. And It's distributed by the chief clerks through the administrative register in the way most executive branch reports are.
Thank you. And then my second question is tweaking our agreement. What's the process of tweaking? I think the previous person who was testifying talked about Oregon and other states that have been tweaking as they go along. How would we do that in Wisconsin?
From the perspective of the bill,
Mm-hmm.
the board, the J-Lab, or what are we calling it? D-Lab, J-Lab. The D-Lab would be responsible for making those changes, and those are reported in that report on pages 7 and 8 for distribution to the legislature and to the governor.
Thank you.
Let's see, we have Representative Walks.
I'm interested in page 7 of the bill, lines 3 through 7, maintain and administer a complaint resolution process. It indicates also the complaint resolution process shall require complaints to be first addressed at the institutional level, perhaps for alleged counsel. Is that a condition preceding prior to other actions? It's necessary to go through that first?
My understanding is that is what SARA requires in this case.
It does.
I'm sorry.
Sorry to interrupt.
NC-SARA.
It does. It requires that you go through the process at the institution first. And in fact, that is the way the federal regulations requiring complaint processes at institutions and at the state level, it also enumerates that. You exhaust the institutional process first. So we're just piggybacking and being parallel to what the feds and all the states and the accreditors do.
And let me follow up if it's all right, is the consumer, Wisconsin consumer then looking to the law of other states for final resolution?
Yes, so I'm going to try to use an illustrative example. So let's say you have a student, let's go back to the one we've been using today. You've got a student in Wisconsin taking online courses.
With his online.
Bob is taking an online course from the University of Phoenix, and therefore he would make his initial complaint through the University of Phoenix process. And let's assume that they do not resolve to his satisfaction or on his behalf, on his side. He then would take that to the Arizona portal agency. Now, let's assume Bob doesn't know that, though. So Bob would contact EAB or D-Lab or me. I get a lot of calls from folks about where do I go. And so he would eventually, through all of those folks, get to the Arizona portal agency. So the Arizona portal agency would say, okay, if you can show that you've exhausted the institutional process, write up your complaint and we're going to take a look at it. Now there are certain complaints that never can rise above the institutional level. Student conduct complaints, if those don't rise up, and neither do student grade disputes, those don't rise up. And again, that is a standard across the industry. That is not something SARA made up. But let's say he's saying that there is a problem with their online offerings. Maybe they don't have enough tech support or bandwidth. And that would be a clear violation of CRAC guidelines. But for whatever reason, they disagreed. The Arizona portal agency would have the responsibility to look into that and figure out exactly what's going on. First of all, to resolve it for Bob, but also to resolve it with the institution in general. But before doing that, they would also be calling D-Lab and putting them on notice that Bob, who lives in Wisconsin, has a complaint and that they will be following up with them. That's mandatory. They have to do that. So.
There's nothing in this that would prohibit Bob from suing.
Nope, nothing.
Phoenix or the Idaho company, college or whatever,
No,
correct?
no.
And what about arbitration? I had asked a question earlier about, do these online outfits, do they put arbitration agreements in the contracts when these kids sign up?
I know that there are some for-profits that are pretty sneaky in the things that they sneak into that initial contract. And actually, those are a number of the things that are beginning to be ferreted out as they are having to apply as SARA schools and as they are beginning to have more scrutiny nationwide. So I can imagine that there are those that still have those provisions in their contracts, but that would still be under the laws in this instance, under the arbitration laws in Arizona. So again, it would go through that process. Now, that being said, the bulk of the times that a student falls prey to something like this is when the student had no idea that that was really in there, or that it was pertinent, or that it would have any impact on him or her. So there then are issues of fraud and a contract dispute, which then, of course, will go to the Attorney General in Arizona. And again, the portal agency there would be instrumental in helping him get there and get that taken care of, which in the past, it's really difficult for students to figure out where to go, to whom they should appeal, and how they do this, how they phrase things, you know.
Does SARA have the authority to mandate that these colleges not have arbitration agreements in there?
We do not have that authority at this point. I haven't heard any discussion of it. One of the things we're trying to do is bring everybody into the tent and say, listen, let's all play by the same rules. So there's a tremendous amount of pressure on these institutions to do it. I will let you know too that fewer than 3% of the institutions that have joined SARA are for-profit institutions. It's a very, very small number so far. But we don't have the ability, we're not the law. We can't ask them not to have these things in their contracts, but we do require them to follow the CREC guidelines, again, for distance education, which does have a lot in there about false advertising and fraud. And of course, these schools are always susceptible to the jurisdiction of their state Attorney General's office.
You've mentioned now with regard to wideband or online offering, and just now you talked about CREC. What is CREC?
CREC, the Council for Regional Accreditors guidelines for online education. Those were enacted in, those were drawn up by the Council of Regional Accreditors, which are the major accrediting bodies in the U.S. In 2011. They're the gold standard of online behavior.
And how do they play with this? I mean, how does that all fit in?
Yeah,
with
those are
SARA?
required. You have the president, provost, chancellor of the institution has to sign off that they meet those guidelines at their institution in order for them to submit a SARA application. Prior to SARA, if they were not regionally accredited, if they were only nationally accredited, they did not have to meet those requirements, and no one at the institution had to guarantee it.
So before they're a SARA school, they've got to get through this.
They have to
condition.
be CREC compliant, correct?
And this is available online?
Absolutely, and I can definitely get you as many of these things as you would like. Happy to.
Thank you.
You're welcome.
Other questions? Thank you for coming back. We will
Thank you.
go on to, the next person testifying will be John Reineman from the Higher Education AIDS Board, speaking in favor. Welcome, Mr. Reineman.
Good morning, Senator and members, representatives, senators. Thank you for having the hearing today. I did want to come and speak in person. I initially prepared a statement, which I think you have, saying that I would not be here in person, but it was pointed out to me that perhaps my presence would be useful, so I ducked in today from vacation. HEAB is going to be the entity that will serve as the staff support or the staff point of contact for this new entity. Let me walk through my statement very, very quickly, come back and cover a few points that have been discussed here. HEAB, the agency, certainly supports the bill, and we have been talking to the academic sectors involved about our intended role as being the central point of staff support. But we are not going to be the only point of staff support. We are going to be requiring the help of the staff in the sectors to do what we do, collect the data, work through complaints, ambiguities, other issues. It's something we do now. I know that they have all pledged their support. It's been a very collaborative process, and I really don't anticipate that that would change going forward. We are the state's higher educational aid system. We do not in Wisconsin have a comprehensive Department of Higher Ed. What HEAB does is we run the higher aid program. What EAB does is that it regulates and oversees the for-profit, private academic sector. To some extent, they are a state agency, certainly, but to some extent, their role is almost that of being an advocate for that academic sector. And I'll get back to that in a minute, because I think that comparison is helpful. Let's see here. Obviously, the Distance Learning Board is to be the portal entity. We've been talking in terms of SARA and its need for this state, if it is to participate, to have a portal entity. We don't currently participate in SARA, so we don't currently have a portal entity. Nothing in the bill that I've seen, I think I'm on firm ground here, nothing in the bill that I've seen eliminates any of the sectors or their entities from doing what they now do. The bill would change some of the functions that they perform, but nothing in this bill is going to eliminate, for example, WACU, the Wisconsin Association of Independent Colleges and Universities. They're a sector entity. The UW and its Board of Regents are another sector entity. Another sector entity is the tribal colleges, but to an extent and in some ways, I think it's important to remember that what EAB does is serve as a sector entity as well as a state agency. And I'll point very briefly to the issue of transcripts. Where do transcripts go when schools close? It's a great question. We get it at HEAB occasionally, and we have to refer people to the proper place. The UW is the repository, for example. We've never seen a comprehensive campus close, but what happened to the transcripts of all of our county teacher colleges? The last one of those is 40 years gone now this year, but what happened to them? They're all with the UW. What happened to the transcripts of Racine College, Mount Scenario College? They're all at WACU. The official statutorily designated receptacle safeguarder for those transcripts is the Association of Independent Colleges and Universities, who, although they are an association, they serve this role as a public records repository. And in fact, they function as a sector in another way. They make a recommendation to HEAB, to my board every year, about what the grant formula should be for our principal financial aid program, the Wisconsin grant. So in higher ed in Wisconsin, we do have some cross-pollination between how a sector and an advocacy entity works, and I think that's making these conversations a little more difficult to follow. Certainly EAB retains the transcripts of all of the closed institutions, and there are many of them. If you've ever looked online at the list of all the closed for-profit private institutions for whom EAB is the central repository of transcripts, there are dozens, I believe hundreds of them. And nothing in this bill changes any of that. Those transcripts are still going to remain right where they are. The question of credit transferability, I think, first goes to the institution to whom a student wishes to transfer the credits. And after that, things differ a little bit depending on where the institution is and what sort of institution it is. And that's not principally something HEAB is involved with, so I don't want to go too far down that road. But I found when I was asked whether HEAB would be willing to be the central office to staff this board, I found it helpful to think of the Distance Learning Board as a board, and the HEAB office as the place where it would go for its clerical functions. Someone is going to have to publish these meetings, make sure that the board agendas are prepared, things like that. We currently work with 4 of our academic sectors right now to prepare the reports we're expected to prepare on things like higher education participation and things like that. This would continue that role for us. So in some ways, I think it's a natural fit. I guess I would like to point out that there isn't a fiscal note from the Distance Learning Board because they don't exist yet. There is a fiscal note from HEAB. We initially talked to the sectors involved, all of whom have repeatedly said that they will provide us with whatever help they need. I have a deputy at HEAB, a civil servant, who is very devoted to the agency, who feels strongly that there needs to be some staff resources devoted to this entity if it is created and if Wisconsin participates. And I think she's accurate in saying that it's going to require a full-time person. I don't know that it absolutely has to be one single full-time person at our agency. But you heard earlier how there was language placed in the bill allowing for fees, which no one is currently anticipating a need for. Frankly, that was the impetus of this fiscal note. There's going to need to be some work here. It's going to fall to HEAB to coordinate it. It is my hope, but it is also my belief that HEAB will not, in fact, need to hire a staff person. I think we'll need someone who is apprised of these issues. It will probably be me for the first year or two of this. And we're going to have to make sure that the requests for information and support to these sectors are given out, collected, collated, and turned into a report. There was a mistake in our fiscal note. I want to confess. We should perhaps have checked the box that says program revenue. We wrote that fiscal note on the supposition that if fees become necessary, they would be program revenue fees, and if a position becomes necessary at HEAB, that it would be a program revenue position. We don't currently have any program revenue positions. We are in the GPR agency. So I think that error in our fiscal note, which I did not catch until this morning, is partially to blame for some of the chagrin you may have heard about the presence of our fiscal note. It is not my intent to seek a position for this. It is not my intention, certainly, to seek any GPR for this arrangement. I really believe we can do this with the help of the sectors. And if after a year or two it proves desirable to give more resources to this, then I think the sectors will collaboratively participate in a discussion about what fees will look like, where they should go. They'll be funneled, I am sure, through DOA and through the appropriation process. So wanted to touch on those points. With that, I did want to stress the support of HEAB, the agency, and HEAB, the board, for this bill, and answer whatever questions I can for you. So,
Thank you very much, John. And I appreciate your explaining the fiscal note. I think as the bill was put together, specifically for those who have it before them, it does say in regards to staffing that the DLAB board would require each agency to cover this, to provide the staffing resources needed for the board. And so that is the intent, and you've explained how that would work. So, questions, Representative Brousseau?
Just a question of either our speaker or the authors. Do we need to have a statute on the books regarding a repository for online transcripts? He said that we do have that for the other schools, for the UW and Waco schools. Would it be good to also have that in our statutes?
well, I will attempt to answer, but I'll confess right off that this is beyond my responsibility because it is EAB who serves as a repository of transcripts rather than HEAB. So it's not something my agency currently does. I'm going to extrapolate a little and conclude that if we currently believe that all institutions in Wisconsin have something in our statute requiring that their transcripts be kept and made accessible, I think we've probably punched that ticket, but it is a question that I would like to see us explore about what happens to the transcripts of an online institution not based in Wisconsin. And I think the conclusion I've come to is the first point I'd want to confirm is probably the other states where those institutions are housed have statutes that would cover that. That would be my first conclusion.
If I could respond to that, Representative, my understanding from Jenny Perks that just spoke and answered some of the questions was that that is a requirement of the portal entity.
Okay.
And that is something that has to be, that's required, and that without that, they're not approved.
Okay.
That was my understanding.
Thank you.
All right, other questions? Representative Jorgensen.
Thank you, Madam Chair, and thank you for being here. And I just got a quick question. You may have already answered it, but I just make sure. But can HEAB contract with EAB instead of asking for state funds to create a position to do EAB's job?
Well, I guess, Representative, I'm not expecting that question. I guess my first response is we can certainly do a memorandum of understanding with any other agency or with an association for work that we feel needs to be done, so that's an avenue I'd want to explore. I don't anticipate that the first thing to happen here would be a contract or a memorandum of understanding with EAB, because, as I've said before, in the context of the Distance Learning Board, it strikes me that EAB's role is almost in some ways that of a sector rather than just that of a state agency. It is both here, but I think there may be a need to formalize the data sharing relationships between HEAB, if we are the clerical repository and preparer of these reports. There may be a need for us to clarify and formalize our relationship not just with EAB, but with all the sectors. And I anticipate that they would cooperate with us in that. They always have, and they always have in the context of this discussion.
Any other questions? Hearing none, thank you very much for your testimony. Next, we have Matthew Davis from, how do I pronounce that?
Maranatha.
Oh, Maranatha Baptist University, speaking in favor. Thank you, Matthew.
Thank you, Madam Chairperson and Mr. Chair. And it's been interesting to hear the back and forth, and I had no intention of having to carry the water on exactly why we needed this, but I did want to give you some perspective from Maranatha as a small, nonprofit, accredited institution here in the state since 1968, and tell you a little bit about why we're in favor of this, very much so, and have been working as much as we can to understand the solutions that have been proposed, and certainly at this point to agree with them. I can assure you that the impetus for SARA is not hypothetical for us, nor can the regulatory nightmare that we currently live under be characterized as overstated in any way. In fact, I'll show you what we deal with in just a moment. The current status quo threatens to disadvantage Wisconsin institutions and our citizens if we don't act very, very soon. So we support the swift enactment of the bill under consideration. As you know, regulation of online higher ed is a complete and complex patchwork, with every state enforcing its individual unique requirements for online courses offered to students located in that state. Maranatha has a robust catalog of well-respected online courses and degree programs. Maranatha is accredited by the Higher Learning Commission, and we are approved to offer online courses and programs at the undergraduate and the graduate levels. In fact, our distance learning programs received special commendation by the Higher Learning Commission, and I was interested to see that just last week, U.S. News & World Report released its rankings, and Maranatha's online bachelor's programs were ranked in the top 3% of colleges and universities nationwide. Also makes Maranatha the highest rated private institution for online programs here in Wisconsin. So little old Maranatha from Watertown, we're doing our best to offer a unique product and a good quality product. In spite of the academic quality and integrity of our programs, the growth of Maranatha's distance ed offerings has been stunted by incredibly complex and expensive demands from other states. Because we are not part of the SARA consortium, Wisconsin schools must submit to the demands of 50-plus other jurisdictions, including other states, Guam, Puerto Rico, the District of Columbia, etc. Our spreadsheet cataloging the requirements of every jurisdiction is over 270 pages long. I brought it with you as an example, all right? I have an assistant corporate counsel that worked all summer long. I can assure you the chart that's found on the National Services website was last updated in 2012. It's way out of date. This spreadsheet that was updated this summer is already way out of date. It's a changing, shifting, complex scenario. This environment outside of SARA gives each state authority and incentive to create its own regulation and impose fees on foreign schools offering online courses in that state. It's the worst possible scenario. So many different and often contradictory regulatory regimes, increased compliance burdens, and registration fees that are frequently excessive and prohibitory. By the way, our compliance confidence level at any given moment is very low because of the fact it's an ever-shifting landscape. Some states require foreign schools to register with multiple agencies within the state, such as Alabama and California. Information provided by the states themselves regarding application processes, exemptions, fees, often contradict the information given to us by other agencies within that same state. An exemption that's offered by one agency within a state may not be recognized by another. And we've seen some states that are frankly proactively hostile. Maryland famously sent cease and desist letters to colleges across the nation. As a result, Maranatha restricted Maryland residents and said we will not offer online education in that state. Remember that, because you need to understand that we are everyone else's Maryland. Michigan chose to join SARA in June of 2015, and as was mentioned earlier, immediately then contacted all the schools that had students from outside, all the outside schools, and sent us a bill for $10,000. That is an incredibly prohibitive thing to do for an institution like Maranatha that may only have a handful of students in that state. So SARA brings the benefit of reciprocity. Once we join the compact, institutions reported to SARA are automatically approved to offer online education in all those member states. This completely solves our regulatory nightmare. We will no longer have to track compliance in all those other states or pay fees and seek approval for our distance offering. Unfortunately, even though we have meaningful agreement in the higher education community here in our state, we're one of, as I count it, only 2 left that haven't agreed that this is something we need to jump into. Wisconsin and Massachusetts, as far as I can understand. At a time when the Higher Learning Commission and the United States Department of Education have made specific appeals to us for innovation and leadership in the manner and the methods by which higher education services are provided, Wisconsin institutions are severely hampered in our efforts to do just that. This bill will establish Wisconsin's higher ed institutions in a positive position for competitive online programs. The bill creates the portal agency. It has fair representation from the 3 higher education sectors, public, technical, and private. This approach is very worthy of consideration, but it does raise some concerns for Wisconsin. WACU, the Wisconsin Association of Independent Colleges and Universities, is proposed as the private college representative. Not all of Wisconsin's private institutions are members of WACU. In fact, Maranatha is not. We appreciate very much the service that WACU provides, and we generally support its policies and positions, but we've not chosen to become a member. Having met with WACU leadership and gained the assurance that WACU will diligently represent the interests of both members and non-members, that membership is not a requirement for DLAB qualification under the proposed language. We do now support the legislative language that's under consideration. The principle, though, that public benefits should not be conditioned on private membership is foundational to our support for this proposal. So I see this proposal as a win-win-win. Number one, it unleashes the potential for higher ed institutions as we've talked about today. Number two, it opens up much wider opportunities for the citizens of Wisconsin to seek online college opportunities from institutions outside our state. Currently, this state is a very difficult place for such institutions to operate. Let me put it this way. If Maranatha was not located in Wisconsin as a brick and mortar institution, it would be on top of our list as states to avoid because of the red tape we'd have to cut through. Number three, it maintains important protections for consumers to pursue a remedy if they believe their rights have been injured. That's as important to us as an educational institution as it obviously is to the members of the committee here today. In summary, we're very thankful for this legislature's action in this critical area. This bill will restore Wisconsin's colleges and universities back to the leading edge of innovation where we belong. Wisconsin's entrance into the SARA consortium through the creation of this portal organization creates a very minimal footprint of bureaucracy and prevents additional layers of very unnecessary regulation with regard to higher education. That's very important for us as institutions. The amount of time and energy and staffing and resource and money that we have to put into bare compliance is all time and energy and money that we can't put in to innovation and educational services for our students. And finally, this proposed bill explicitly outlines the requirements for qualification, and it does not require membership in a private organization in order to be approved. And for that, we're very thankful. Thank you again for allowing me to share our perspective.
Thank you very much for your testimony. Any questions of Matthew? Hearing none, thank you very much for sharing your comments. That concludes our sign up for people who want to testify. We also have registering but not speaking. Layla Merrifield from the Wisconsin Technical College District Boards Association registering in favor, and Mary Czech Murashinsky from Marquette University also not speaking but registering in favor. So that wraps up our hearing on this legislation. We will now move into the informational hearing on the accountability measures, and we would call President Cross forward and anyone else he wants to bring with him. Welcome, President Cross. And this is a follow-up for committee members. We had a previous hearing on the accountability measures a few weeks ago. And there were a couple of issues that we wanted you to flesh out, including in these, and you're here to cover those additional measures.
Thank you, Madam Chair. Does everyone have a copy of this sheet? Has that been distributed?
I believe, no.
Coming around? Okay. The information, and I'll cover this a little more in detail, but the information before you today is very similar to what I shared with you before and we discussed at that time. But two areas have been enhanced based on feedback we received from the committee and others. So let me start with the area that I think is the most significant. Graduate outcomes on page 4, when you get the sheet. We are working on 2 sets of data that will give us both a short-term and a long-term view of the economic impact and placement rate of our grads, and I think that's important, both short-term and long-term. And that was what we were struggling with before. First, if you look at the bottom of that page, the last 2 items there. First, our institutions are already conducting surveys of alumni 6 months after graduation. This data is helpful. It helps us determine the short-term benefits of the degree, and we can find out if our graduates have jobs, how much they earn, where they live, where they work. But we also felt it was important that we have a longer view of that. For a longer term view, which is the second item, we're partnering with DWD to conduct a significant study matching the DWD UI data with the graduate data we already possess. So connecting those and integrating those in a way that helps us determine if our graduates are employed, how much they make, what they do for a living, 5, 10, 15, 20 years after graduation. And we plan to conduct this this particular survey every 3 years on a regular basis. So it's meant to complement the short-term effort. The final change, the other area that was brought up, the final change from the previous document is on page 1, and it's the bottom of page 1, where we've added simply the reporting of the fund balances year over year in the tuition category. So you see that. This is the tuition fund. This is what's in that fund and has been in that fund year over year. Those are the 2 major changes that we have. Major, they're actually minor. We talked about them to some extent before. Before I take questions, I just want to review the format we've presented this information in, since this is slightly different. Let me use the overall financial health as an example. So that's the very first category on the first page. As you can see, the measure we're using is the CFI, the Consolidated Financial Index. That's the index that's used by the accrediting body when they evaluate an institution. And it's a bit complex because it's a composite of 4 categories. As you can see in the explanation area, it contains 4 components: the primary reserve ratio, the net income ratio, the return on net assets, that ratio, and the debt management viability ratio. What an institution is seeking is a ratio greater than 1, and that's the measure we'll use in looking at that. So you see that in some cases we have a benchmark where we're comparing ourselves to national peers of comparable institutions, and or we're looking at a comparative analysis over a length of time, a longitudinal study, if you will, or what we call a historical trend. If you recall, we had some discussions about goals or targets in the previous discussion when we talked about this. We did not include those in this process in an effort to secure your approval for the goals, but we will have system-wide and specific goals. Some of those goals will be system-wide, some of them will be institutional, some of them will be a combination of both. We will include those when we submit reports on a lot of this. At this point, if you look at the second item there, cost per degree, and the way we will calculate that measure is by using educated, specific educational, and related expenses, and divide that by the number of degrees we produce. So what does it cost per graduate? We have a sense of that, and I can give you that information, but how do we set a target for that? What should that be? And maybe we won't. Maybe we'll simply report that so everyone can see it. And that's part of the goal here, is to be transparent and also to be held accountable. But as we develop these by institution and or by system, we will report them, and a part of that, not only on the dashboard, but in a regular reporting process to the legislature. Finally, I would like to add that this is not the only accountability reporting we're doing. We have 47 reports we provide you on a regular basis. And this accountability dashboard that we introduced to you before, we think the dashboard, which you can access at any time, you can actually analyze data, move it around, question it. We think that's really important. These 4 major categories and the accountability measures, how we're going to be measured in this, will be embedded in that, and you can pull them out separately should you wish to do so, online at any time. We feel we've taken incredible steps, and we've become more transparent, more accountable, and we believe this is an important improvement for the university and for the state. So I would be happy to answer any questions or any concerns you have about any changes we've made or any issues you have.
Thank you, President Krause. I want to thank you for your work on, we've had many conversations over the last several years about the importance of measures that we can measure the importance and the effectiveness of our campuses and the system. And so your work on the dashboard, I think that data is going to be extremely helpful, not only to us as policymakers, but I think it's going to be helpful to students. I think it's going to be helpful to campus administrators as well as system administrators, and be valuable in the years ahead. Specifically, one of the things that I think as we've looked at requiring these accountability measures specifically, it's important that we have a feel for job placement. The technical college system has long been doing a good job on identifying job placement, and it's something that we haven't seen that as much from the UW system. Obviously, Stout has been doing it for a long time, but I think you're putting together that metric. It is important that we, as well as campuses, know that they are turning out degrees where there is a demand and that students are finding employment opportunities. So appreciate your work on that. I suspect that these measures may be tweaked. We may need to tweak them down the road to make sure that they are the measures that are important for us as well as you on campuses. When you said every 3 years, just a question on, you said Okay, so the alumni placement, can you go through the timeline as far as how often you're collecting the data again for me?
Yes.
On
the last,
specifically the John.
yeah, on the last two. On the alumni placement, that is the same survey you're talking about. It's very similar to the technical college surveys. By the way, most of our institutions were doing that. Some were doing it by school within the university. It just wasn't shared widely with us, so it's a matter of aggregating that information. And as the senator mentioned, Stout has probably done that very aggressively for a long time. That will be done on an annual basis. That survey will be taken on an annual basis. The long-term piece, I think, is really important. It's similar to what is being done in Texas or Virginia, probably more similar to Virginia than Texas in some ways, but in other ways it's a little different. It allows us to take data from DWD, and which is basically employment data, and match it with information we have about graduates and determine every 3 years, are they working here? What are their earnings? What's their job position, job title? It allows us to validate in some way a survey that students or graduates, respond to on the short-term side. Is there greater validity? Are we doing what we claim we're doing with short-term self-reported information by validating this on the backside every 3 years? We think that lends to the data we provide reliability and validity, which I think is important, greater validity.
So, and that, my recollection is that is only can be measured for in those who stay working in our state.
Yes, that is currently only for those people working in Wisconsin. However, there's some recent discussions about being able to share that with Illinois and Minnesota perhaps as well. I'm not sure about the states beyond that.
Do you happen to know what percentage of our graduates stay within our state after graduation?
It varies by institution, but if we pull Madison out, I'll come back to Madison in a second. Pull Madison out, it's somewhere between 80 and 85%. It's around that number, graduates who stay in the state. Madison is somewhere in the 60s. I'm going to say 65%, but it's in that range.
Okay, thank you. Other questions of committee members? Yes, Senator Nas.
One of my concerns, which I've expressed in the past, is as I look through this in several of the categories, where you're comparing to peers nationally, and it reminds me of the reading scores, which are not great in Wisconsin, and occasionally I'll see a school district say we're above the average, when the average, when you look, is it would equate to a D or an F. And so, and they're happy about being a little bit above the average, but still failing. And so I'm not sure if other institutions, and as I have expressed in the past, is that if we look at what other peers are doing, that may not be good enough when you collectively take it. And we may want to set a target above that. And I don't know that there's historically, and we're on a different day with yourself, but whether there's a fear to go beyond that we'll never reach that, and then we got to go back to the legislature and tell them we didn't hit our goal. I guess time will tell. But that's one of my concerns when we say we're gonna look at our peers nationally. That may not necessarily bode well for let's do better. That's all. Just a comment.
Thank you, Senator Nelson. I think that's a very valid concern, and I would share that. Some of these items, I think it's really important within the benchmark that we understand how do we compare, but that doesn't substitute or shouldn't be a substitute for where we should be. And so that's why the goals or the targets will be separated from this. This is, I think you want to see how we compare to other institutions around the country, but that doesn't necessarily mean that we should be like them. And it just gives you a point of reference in that. And as an administrator, a manager, trying to make decisions, well, wait a minute, why is it we spend so much more money producing that degree than someone does in Illinois or elsewhere? What is it? Well, there may be legitimate reasons, but that may raise and prompt some questions. It may also prompt us to change the target, that the goal, if you will, in that area.
Other questions? Representative Chairman Murphy.
Thank you, Senator Harsdorf. And thank you, President Cross, for testifying. And I would like to echo Senator Harsdorf on her comments about the dashboard. I think it's, I'm just trying to emphasize what we're trying to do here. And I think what we're trying to do here is we're trying to get more information out there. It's about accountability. It's about trust with the university system, and I think we are making great strides there. I look at the information, whether as a legislator, it gives me so much more opportunity to go back and find and look at numbers. And I can always go back and compare them to something else. And obviously, it would be nice to always have the perfect goal or the perfect standard there to compare it to. But many times, you know, as legislators, we're going to have to go back there. We're going to have to go back and do some research and find out, you know, what that is and what we need to be looking at. And I think you would agree. I mean, this is an ongoing process. I think we are pressed with the task here of saying, has the university, you know, made a significant effort? Have they put up a very good initial product? And in that regard, I would say, you know, definitely, I think that you have.
Thank you. If I may I respond to this? I hope at some point that I want to pick up on something Senator Noss and I have had conversations about. So, in essence, we share the same goal. How do we do this in an open, honest, ethical, upright way? And how do we set the appropriate targets? At some point, I hope you don't have to do that investigation. You say, okay, we trust the university to do the right thing and to push that goal to an even higher standard. And I know that your responsibility is to hold us accountable. I support that entirely. But at some point you have to say, well, they're really trying to do the right thing here. And I hope that at some point you will have that confidence in what we're doing. This is a step, I think, in that direction. It is not the final step.
Senator Bewley.
Thank you very much, and I appreciate, I know that accountability is incredibly important, and we are looking at particular categories that address how well we are doing what we do now. How well are we responding to the immediate needs of Wisconsin's economy? I have a very particular question, and then I have a hard question. My first question is about cost per degree. Do we care that the cost per degree, if it is truly broken down, of an English major or an education major is less than the true cost for a degree of a graduate in biomedical engineering? Do we care?
I would suggest that that's probably not something that you should care about, but it's something I should care about.
Okay.
Are we doing the right thing? Perhaps we're not investing sufficiently in that degree. If you're the chancellor or the president of an institution, and you outline, if you're capable of outlining and identifying the cost of to deliver every program on that campus, you will have some programs that make you money, to put it in a corporate term, and some that you lose money on. But you're responsible because as a public university, these are things we must do. when you compare the makers with those that cost you money, you have to balance that out, particularly if you're a private institution, so you don't get too distorted in one direction or the other. But as a public institution, our mission plays into that picture as well.
I guess what I am suggesting is the ability to show that the diverse curriculum that you offer is cost effective, because as we push for STEM, we need the humanities to subsidize STEM. We just have to, or else you couldn't teach all STEM and charge the tuition that you are. You'd have to charge or get more money or something. But I guess we don't have a metric that shows that the more diverse the student body and the more we have people who are coming there for English, for education, for philosophy, that subsidizes the person who's taking engineering or chemistry or physics.
Thank you, Senator Bewley, for serving me a softball. I get to perhaps get on my platform just a little bit, and I think we don't just offer the humanities because they're cheaper to offer.
I know you don't.
We don't. I think it was Winston Churchill argued during World War II when they came to him and said, you're going to have to shift money from arts and humanities. You're going to have to shift that money over here to the war effort. And his response then, what are we fighting for? I think the balance of and the importance of STEM is incredibly important. But what has separated America from most other countries is the creativity and the innovation that accompanies STEM. It's the idea from the Wright brothers, who ran a little bike shop, who said the data that the major scientists were producing on air flight wasn't accurate. It didn't work, and they figured it out. From my perspective, I think the arts contribute to that innovation and idea, and the aesthetic appeal of an Apple product is what propelled that into such a market position, not just its performance. So I'm speaking in defense of the humanities and the arts in a way that if it complements the STEM programs correctly, you have a powerful, powerful economy driver and a citizen improvement process.
But is there a way that we can measure that?
You have to measure it. But you also have to make a commitment to those issues. Leadership and the state has to make a commitment to those issues and understand it. But I would argue, I hope, that the delivery of the humanities programs isn't just an economic trade-off.
Indeed, indeed. The next one, the question that I wanted to, you meant, it is referred to, pardon me, research and public service funding. We know that the ability of the University of Wisconsin to lead the nation in pursuing the next great thing is significant as football. I mean, it's a big deal. Do we have a way to measure that? How we innovate, how we dream big and do great things. Is there a metric for that?
This is an attempt, albeit I think a weak attempt, to try to recognize that. Now, having said, why do I say weak attempt? I don't know what else to do. If one says that how much money you get to perform research is a measure of your success, I think that's probably misleading as well. It's a measure in your success of securing grants. It's also dependent on federal funds. Are they available? So I'm not sure this, and I think Senator Harsdorf, before, when we talked about this at some point, we grappled with how best to do that. Is it Is it based on a percentage of the research funds available? Well, then how much work are you doing to pursue those funds? So this is an effort to try to give an indicator there, because your point, Senator Bewley, is a really good one. That is a huge factor in the economy of this state, and how we best look at that is yet to be determined, but this is our first effort at it.
Other questions, committee members? Hearing none, thank you.
Thank you.
With that, that concludes the informational hearing on the higher education committees, and we will move, do you have one? Okay, so we will move into an executive session. Now, we've noticed it for both the accountability measures, because the statutes do call for us to have a committee vote. It won't go any further than that, but a committee vote. And then we also noticed Senate Bill 511 and the Assembly Companion. We are given the questions that were raised and providing you with the opportunity for further clarification. And out of courtesy to committee members who have asked that we delay a vote on the legislation, the SARA legislation, we will do that. We will respectively notice it. It is our intent to bring it up for a vote soon so we can get it to the floor and with limited session days. But you will receive a notice on the executive session for that. So moving into the executive session, we will need a motion to approve the accountability measures. Do we need a? Oh, okay. Okay, so we get to go first.
We're just doing it as a vote, not like a motion.
Okay, and then we will hold the executive, the roll call, will mirror the roll call from the earlier hearing for the executive session. And so, would we need a motion, Ledge Council, or can we just hold a vote in favor? Okay, okay. So do I have a motion to approve the accountability measures as presented before us? Senator Bewley, and a second? No, you don't get to vote with us, Representative. Nice try, nice try. I will second the approval of the accountability measures, and the clerk will call the roll.
Senator Harsdorf.
Aye.
Senator Noss.
No.
Senator Gudex.
Aye.
Senator Hansen. Senator Bewley.
Aye.
Motion passes.
And we will leave the roll open for Senator Hansen. And with that, that concludes the Senate portion of the Higher Education Committee.
Thank you, Senator. Now we will go into the Assembly, Colleges and Universities executive session, and I'm going to...
Has left the conference.
Oh. Thank you, Senator. We're going to have the clerk call the roll because we've had a lot of members in and out. Just going to assure that we have a quorum.
Okay. Oh, sorry. Representative Murphy?
Here.
Representative Brooks? Here. Representative Rohrcast? Representative Quinn?
Here.
Representative Rodriguez? Here. Representative Petrick? Here. Representative Ballweg? Representative Krug? Representative Tranel?
Here.
Representative Mako? Representative Walks?
Here.
Representative Brousseau?
Here.
Representative Billings?
Here.
Representative Hesselbein?
Here.
Representative Jorgensen?
Here.
I would now entertain a motion to approve the accountability measures. Representative Petrick and Representative Quinn is seconding. Call the roll, please. The vote. Oh, yeah. We will now vote for approval of the accountability measures report that the UW Board of Regents submitted to our committee.
Representative Murphy?
Yes.
Representative Brooks? Representative Rohrcast? Representative Quinn? Representative Rodriguez? Representative Petrick? Representative Ballweg? Representative Krug? Representative Tranel?
Aye.
Representative Mako? Representative Walks?
Aye.
Representative Brousseau?
Aye.
Representative Billings?
Aye.
Representative Hesselbein?
Aye.
Representative Jorgensen?
Aye.
And the accountability measures are approved.
You and him, better stuff.
Thank you. Thank you very much, members. Just want to let you know that we will be looking at a meeting soon, probably next week, to look at execing on the NC-SARA. So please get your concerns and questions, to the appropriate people, so you can make your decision.
Don't blame the devil yet.
Okay.
Yeah.
I gotta talk to him about something.
Why?
Because
we have enough votes, don't we?
Well, thinking,
We're gonna hold the vote open for like 2 minutes. There was 1 or 2 members that wanted to vote on it. We're sort of adjourned. And how do you vote on the accountability metrics?
Looks good to me.
Aye. Great. And the 2 minutes is up. Meeting is adjourned.